I'm really delighted to be able to welcome you to today's program, Understanding Trump's National Security Tariffs. It's a very hot topic as of, some time back, but also since just last week. My name is Anna Helm, and I'm the faculty director of the GW-CIBER, the Center for International Business Education and Research, here at the George Washington University. We're located actually in the business school here on campus. GW-CIBER is one of 15 such centers across the United States, funded by the Department of Education, with a broad mandate to increase the competitiveness of U.S. firms abroad. To this effect, we support international business research. We design and offer educational experiences for students and do outreach to the business and policy communities. GW-CIBER has a particular focus on institutions, inclusive globalization, and U.S. competitiveness, a theme that resonates with the capacity and interests of our faculty here on campus. Together, the CIBERs around the country form a powerful network focused on meeting the demands of U.S. firms for competent, globally minded talent and up-to-date knowledge about international business. Today's event is a collaboration with the Association of Women in International Trade, WIT, and the D.C. Virginia District Export Council, the DEC. I want to give special credit to the thought leaders behind this event, Ms. Evelyn Soares, former president of WIT, and Mr. John Saylor, former chairman of the D.C. Virginia DEC. For details about their impressive careers, please refer to their bios in the program notes. Both Evelyn and John serve on the GW-CIBER Advisory Council and have been phenomenal supporters of and contributors to our mission. I would like to take this opportunity to thank them both for all their work for CIBER. Let us now proceed to the first panel. So join me in welcoming Evelyn Soares of the Soares firm, who will moderate this panel titled The Law and Its Limits. Thank you very much.
Thank you, Anna, and good afternoon all, and thank you for joining our program on 232 of the Trade Expansion Act of 1962. The presentation today should provide a comprehensive overview of what's going on. I think you'll find it particularly interesting today. I think you'll find the various dimensions of these tariffs very interesting. I must tell you a little bit about our co-sponsor, which is WIT, Women in International Trade. We are the DC chapter of a global organization called the Organization of Women in International Trade. And WIT has a dual mission to promote women and to promote international trade. And it does it by educational offerings like this and also networking opportunities. So let's turn to our panel. Our panel will examine the law itself and the limits of the law, as Anna just stated. The second panel will address the collateral damage caused by these tariffs. So let me introduce you to the speakers on this panel. First of all, Alan, I'll go just, Morrison is, he is a professor of law at George Washington University, and he teaches civil procedure and constitutional law at GW. For most of his career, he has worked for the Public Citizen Litigation Group, which he co-founded with Ralph Nader in 1972 and has directed for over 25 years. It's quite impressive. He has argued over 20 cases in the U.S. Supreme Court. And notably for this discussion, he is also on the legal team representing the American Institute for International Steel, AIIS, in the litigation challenging the constitutionality of Section 232. Next to me is Vanessa Sciarra. Vanessa is VP for Legal Affairs and Trade and Investment Policy at the National Foreign Trade Council. NFTC is an association of leading US-based international business enterprises representing all major sectors of the economy. Among other things, Vanessa has practiced law in private law firms and in the public sector at USTR and at DOJ. She will provide us with insight on the law and tell us about NFTC's Friend of the Court brief that they supported in support of the request by AIS for review by the Supreme Court. Mark Bush, I didn't go this in any order here, okay, just to keep you on your toes. Mark Bush is the Carl F. Landiger Professor of International Business Diplomacy at the Edmund A. Walsh School of Foreign Service at Georgetown University. He is an expert on international trade policy and law. Among other things, he's a prolific author on trade and expert on WTO matters. If you haven't heard about the podcast he hosts called Tradecraft, you should take a listen. It can be accessed on iTunes or SoundCloud. He will tell us about what's going on at the WTO with regard to the national security exception and how it might relate to the use of 232 to impose tariffs on things like steel and aluminum. Haley Craig is a legislative assistant to Senator Pat Toomey, specializing in international trade, education, and labor issues. She previously worked under Senator Toomey's general counsel on the Judiciary portfolio, as well as the Senate Rules Committee. She will tell us about Senator Toomey's bill to rein in presidential authority under Section 232, as well as the other bills that have been introduced and where they might be headed. So let's get started with our panel. My first question is going to be directed to Vanessa. Vanessa, can you tell us about Section 232 and tell us how it has been used in the past?
So this particular statute is part of a trio of statutes that were post-Cold War, World War II statute, Cold War, post-World War II statutes. So, and this is interesting to me because we're having so many debates about tariff and tariff authority. So pay close attention to this sort of set of events. So in 1955, there was a trade act that was passed to instruct the president or give him sort of instructions not to lower tariffs. And the idea there was to give the president authority to protect industries that were potentially being hurt by an influx of imports. And this was, again, in this national security sense, where we were in the Cold War, we were worried about military preparedness for what potentially could have been a military conflict with the Soviet Republic. So that was 1955. In 1958, Congress said, well, we're going to give you another delegation of tariff authority, but this delegation is going to allow you to raise tariffs. So the first delegation was don't lower them. The second delegation is you can raise them, subject to a certain set of provisions that you have to follow. And the 1962 Act, which was the one that we now work under, was the one that set out the process for investigation by the Commerce Department, consultation with the Department of Defense. Advice is then given to the president, and the president decides what to do. And one of the tools in his toolbox for responding to this national security concern was the ability to raise tariffs. But again, very important to recognize that this was all delegated authority from the Congress to the president. And this sort of ties into a lot of debates we're having between the sort of trade community and the White House about delegation of trade authority from the Congress. Historically, 232 was kind of a trade backwater. In fact, I would imagine that most people in the audience who did trade law for much of their career, like I did, had never heard of it or had heard of it only in very limited instances. It wasn't really used much. There have been 14 investigations prior to the current round of Trump administration activities. There were only 14 investigations initiated, so that's not very many investigations since the 1960s. The most recent investigation prior to the Trump actions was in 2001. Over iron ore and semi-finished steel products, and that did not result in any tariffs. Only 2 investigations have actually resulted in trade restrictions. 1982, there was a crude oil embargo imposed against Libyan exports of oil. And in 1986, there were negotiated agreements with exporters of machine tools, what we call voluntary export restraints, which meant that the exporting countries were willing to limit the exported volumes to the U.S. in response to U.S. pressure that we would do something more severe. And it's important to recognize that the last time we had steel tariffs, which was in 2001, under the Bush administration, this was not the statute that was used. The statute that was used was 201. 201 requires an International Trade Commission investigation. So the ITC is an independent agency. They conduct an investigation in a 201 investigation, and then they report to the president based on their findings. That's to be contrasted with 232, where the Commerce Department does the investigation and the Commerce Department is part of the executive branch, and therefore it's not independent in the sense that it doesn't sit with commissioners and have an independent sort of status. So, so the statute, until the Trump administration started mentioning that they were going to use it a lot, it was relatively, quietly used by limited industries, but it didn't really have much of a profile. And as I said, most of the trade lawyers, when we first heard about 232, we had to go scrambling back to our statute books to look it up, 232, because most of us hadn't had a lot of experience with it. So enter the Trump administration and the decision that this was going to become a major tool for their use. Do you want me to talk about the sort of how we got to where we are?
Sure. Go ahead. You're doing a nice job.
Okay, so as you may know, members of the Trump administration had represented the steel industry for many years and were very conscious of the fact that the steel industry felt it needed protection. They did not feel that the anti-dumping and countervailing duty cases, many of which are in place against foreign imports of steel, and in this case also aluminum, the industry didn't feel that those were effective, and they worked with the White House to have the White House self-initiate investigations on steel products and aluminum products. So this occurred in 2017?
17.
In the spring of 2017, and as a result, the Commerce Department did an investigation. They did consult with the Department of Defense. The Department of Defense wrote an interesting memo, which we can talk about, but they did consult. That was what they were required to do. They proposed to the president a number of alternatives to basically limit imports of steel and aluminum, all of which, they were a range of options, but they included tariffs and quotas, which are the tools of preference if you're really trying to create a tariff wall for imports into this country. And that was given to the president. The president looked at it for a few months and decided that was a good idea. So on March 23rd of last year, he put in place steel and aluminum tariffs for most of our allies who export here. And then a few months later, the tariffs were put in place with respect to Canada and Mexico as well. There were some exemptions. Most of the exemptions required the country that was exporting to either live by quantitative restrictions, or in the case of Australia, maybe live by quantitative restrictions, maybe not. That's a whole other subject. But there were some exemptions, but none of them were really in favor of the exporting country. They were all basically to protect the U.S. industry. So that sort of process of the tariffs being rolled out and then being implemented has meant that by this March we were a one-year anniversary of those tariffs.
Okay, so we've had tariffs for over a year against just about everybody except for those who agreed to quotas. And Mexico and Canada were covered until very recently, where those tariffs are being lifted. Okay, so the law itself has been challenged both domestically in U.S. courts and also internationally at the WTO, the U.S. use of 232. So we're going to focus first on the domestic litigation, and Alan's going to tell us about litigation that his team brought for AIIS in the U.S. Court of International Trade. So please tell us about the litigation.
First, I understand that most of you are not lawyers, and so I'll try to address it to you, and I hope the lawyers in the audience will not mind my simplification. So the case challenges an order issued by President Trump, but the heart of our complaint is not directed at what the president did, as in he violated the law. Our challenge is to the law itself. What this complaint says is that under our Constitution, Congress makes the laws, and that while Congress may delegate authorities to administrative agencies or the president, that there are limits beyond which it cannot go. And when it essentially turns over the making of the law to somebody else, in this case, the president, that's an unconstitutional violation of Article 1 and the separation of powers. So let me give you an easy example to understand what the delegation argument, which is what's called, does and doesn't do. So you all know that national parks are governed by the National Parks Service, and the National Park Service determines the speed limits in the national parks. In theory, Congress could pass a law setting the speed limits, the violation of which makes it a crime, for every national park in the country, or they could set it for all the national parks. Congress instead has said, no, National Park Service, you can issue those rules about how fast you can drive, difference in Rock Creek Park as in other places around the West. And nobody thinks that that delegation is excessive, that the Congress has somehow surrendered its legislative powers to an agency, the National Park Service. The question, though, is what are the limits on that? And since 1935, the Supreme Court has not struck down a federal statute on the grounds that it contained excessive delegation until now. And we are saying that this statute has gone too far, that there are no boundaries, that there's nothing that the president cannot do under the statute. And we illustrate it in a number of respects, but let me tell you first about the features of the statute that we see as essentially open-ended. So feature number one is, although this is supposed to be a national security statute, indeed national security is the first term used, it is in fact much broader than that, because the statute defines national security and allows the President or the Commerce Department to take into account any import that would adversely affect our national economy or any segment or industry thereof. In essence, anything that would have an impact on our economy is fair game under this statute. Second, the tools that the President can use are essentially unlimited. He can impose tariffs, he can impose quotas, he can impose licensing fees, he can have embargoes, or any combination. And more importantly, he can do it in any amount he wants. There's no cap on the amount that he can increase tariffs by. He can impose tariffs where there are no tariffs now. He can do whatever he wants, and the best illustration of this is what he has done with regard to different countries having different regimes under the same statute. And even more significant, what he did to Turkey. Turkey was included in the first group at 25% for steel. Last August, the president, I think it's fair to say, got angry at Turkey, and he doubled the tariffs on Turkey. The justification, and by the way, these justifications don't matter because, as you'll see in a moment, the courts can't do anything about it. He justified it on the grounds that they were not hitting their quotas in terms of tariffs, even though Turkey was only the 5th largest importer of steel products and had been declining every year in the last 3 or 4 years. He doubled the tariffs on Turkey because he could. And then last week, he removed the doubling of the tariffs to Turkey, actually 2 weeks ago, just because he could and did and wanted to do so. He is also not required to treat same countries the same. He doesn't have to take into account the fact that even though this is a national security justification, Canada and Mexico are across the borders from us, and therefore it's not likely to have an interruption of supply if we should have to go to war. We have treaties with NATO. That doesn't make any difference. He doesn't have to treat all countries the same. He doesn't have to treat different products the same. And equally important, as we'll hear about in the second panel today, he is not required to take into account any collateral damage that's caused by the importation of tariffs. So first, broad open trigger, national security capaciously defined. Second, unlimited tools in his toolbox. And third, no judicial review. That is, no matter what he does under the statute, as long as he gets a recommendation from the Commerce Department and acts within 90 days, the courts can't touch what he does. They can't review it for consistency with the statute. He has complete discretion under the statute, and the government agrees that he has that, indeed embraces the notion that he cannot be challenged on this. We say this is too much, that there has never been a statute like this that has been before the court, let alone has been upheld. And we say, therefore, there are no boundaries, a term that comes out of the Supreme Court's leading cases, and that if there is ever a case where the president has been given power from Congress to exceed the power to execute the laws and the power to make the laws, this is it. We filed our lawsuit in the Court of International Trade, which has exclusive jurisdiction over all tariff cases. We obtained the convening of a 3-judge court. These are all, by the way, I had never done a trade case before, never litigated in the Court of International Trade before. These are Article 3 judges, meaning they're just like the judges in the district courts and the circuit courts of appeals. They're appointed by the president and confirmed by the Senate. A panel of 3 judges heard the case, and they rejected our claim mainly because the court had decided, Supreme Court had decided back in 1976, when there was an oil order under 232 that was challenged on the grounds that the president could only use quotas, he could not use licensing fees. And during the course of that argument, the challengers said, this is an undue delegation of legislative authority, and that if you don't if you find that it's we can't do this, avoid deciding the constitutional question by construing the statute to say that you can only do quotas. Supreme Court rejected the statutory construction case in a complete judicial review, and also rejected as unfounded the delegation claim that was raised in that narrow context. We said to the Court of International Trade, you're not bound by that. There was judicial review, and the context in which it arose was different from our case. The Court of International Trade said, well, you know, you got a point, but we think you're bound. We're bound by the Supreme Court, and courts are reluctant to tell the Supreme Court what it meant by the statute. We then had to, our only appeal under the statutes is to the Federal Circuit. But if we got to the Federal Circuit, we'd have 3 more Article III judges who would look at the same thing and be caught in the same dilemma about this case called Algonquin. And so shortly after we filed in the Federal Circuit, we exercised a special right to ask for the Supreme Court to review the case before it went through the Federal Circuit. And we filed a certiorari petition on the 15th of April. The government responded a week ago tomorrow. We filed our reply brief on Friday, and the case will now be before the court in its last couple of conferences on June 20th and thereafter. And we're hoping that the court will grant cert. We've essentially said to them, look, only you can answer what Algonquin means. There's no point in going to the Federal Circuit. There are billions of dollars at stake. The last estimate I saw was in excess of $5 billion for the tariffs alone. And that doesn't count all of the damage to all of the people who are irreparably harmed because they don't pay tariffs, but their business is down because of the reduced level of imports and or the increase in prices that they have to pay. So we will see fairly soon. And if the court grants cert, that'll be a big thing. And if it doesn't, we'll go back to the Federal Circuit and start again.
Okay, I do have a question for Vanessa. NFTC did decide to support this request for review by the Supreme Court. Can you tell us why the organization, made that decision, and what, sort of the reasoning and the focus of your arguments?
So we filed a friend of the court brief. It's right here because I'm really excited. It's my first Supreme Court brief.
It's always exciting.
I'm carrying it everywhere. We did file a friend of the court brief. We were, just to be fair, we were joined by 2 other groups. Cato Institute filed, and a group of farmers from California filed. We all had slightly different arguments. When you're, my understanding at least is, Alan can correct me if I'm wrong, amicus are supposed to bring to the court some additional perspectives. You try not to repeat everything that the plaintiffs have alleged, but you try to bring some additional color to the case. In our case, we spent a good amount of our brief talking about the economic harm that has occurred, both to our companies, but also the economic studies that have been done that have showed how much harm these tariffs have caused American industry. So we were able to bring a lot of information to the court in the form of those studies. We also tried to make clear to the court that we thought this was a case meriting cert. So the court will only take a certain number of cases a year. Cert is something that you ask the court to look at the case. It's not required. And we wanted to bring to the court's attention the sort of damage this was inflicting on U.S. companies every month. And we wanted the court to think, see this case as a case of national importance. We also, as Alan has said, we supported the plaintiff's arguments. So we did spend some time in a brief talking about that. And we basically, one of our concerns, along with all the items that Alan mentioned, was that these tariffs have no sunset provision. So theoretically, they could stay in place for as long as this president is in office, and potentially longer if the president doesn't decide to remove them, and absent some action by Congress, both houses, plus not veto-proof majority, these tariffs could stay in place for a long time, which is really chilling thought for my companies. So that was the reason for filing. We are waiting to see what the conference, the justices are looking at the briefs right now, and we wait to see what happens at the end of June.
Well, this is a good time to turn to Haley to hear about what's happening on the Hill and efforts to rein in presidential authority to impose these types of tariffs and quotas. So your senator, Senator Toomey, introduced a bill. Maybe you could tell us about that bill. And also there are other bills that have been introduced for example, by Senator Portman Can you tell us about where they stand and what the outlook is for legislation?
Sure, happy to. I think we have a little bit of momentum on our side right now, so hopefully we can at least get something through the Finance Committee sometime soon. You use the phrase reining in the president's authority on trade, and we like to think of it as reclaiming, or restoring, I should say, congressional responsibility on trade.
Good.
I wasn't correcting you, I just,
No.
this is the rhetoric we like to use, right? So we like to clarify, right, that this is not, we're not taking away authority from the president. It doesn't belong to the president. And it's always been Congress's responsibility to, regulate commerce with foreign nations. So the only reason, as, Vanessa explained, that the president is even able to put in place these tariffs in the first place is because Congress did delegate that authority to the president with conditions in 1962. So Senator Toomey has introduced a bill. We kind of revamped it for this Congress, but it builds on efforts that he worked on with Senator Corker last year. So we've been kind of beating this drum for almost a year, I think now. But we see the bill as accomplishing two main goals. One is the short-term goal of better trade policy, right? Senator Toomey is, generally a free trader. We think that tariffs are harmful. It's also not really clear what exactly these 232 tariffs are accomplishing besides benefiting a very concentrated group of producers. For example, though, Chinese capacity has gone up, and that's apparently one of the goals of the tariffs, is to address global overcapacity. The job increases in the steel industry have been pretty minimal. We're not making money off of the tariffs. The last number I got from CBP was last week. We've collected about $7.7 billion in steel and aluminum tariff revenue. I believe we paid more in trade aid. And then the exclusions process has largely favored exports from China. So it's kind of if you look at some of the metrics, it's not even clear what is being accomplished here. So that's goal number one, is short-term better trade policy. And then goal number two is the bill addresses a broader constitutional question. Senator Toomey is of the view that over time, Congress has in many spaces delegated far too much authority to the executive branch. For example, over rulemaking and regulations and that sort of thing. So it's not just in the trade space. And we saw this play out with the National Emergencies Act vote on the border wall declaration. So it's not just in the realm of trade, but in this one area of 232, we do see a pathway to kind of restoring some of that congressional responsibility so that legislators are accountable to their constituents when the government decides to raise taxes on them, because that's what these tariffs are. They're taxes. They're paid by American companies and American consumers. So I'll just get a little bit into the details of the bill and then kind of talk about where we see that going within the Finance Committee. Chairman Grassley has been, I don't speak for the chairman, but he's been pretty clear in his public statements that he also views this as a constitutional issue and that he does want to work on 232 reforms, so I see that as very heartening. Senator Toomey's bill does a few different things, and we've worked with Senator Warner this year, by the way, as well as Hassan and Langford. We actually have 5 Finance Committee members on the bill now, along with Senator Scott. The first thing it does is it shifts responsibility for finding a national security determination from Commerce to the Department of Defense. Senator Portman's bill also does this as well. I think that's pretty much a no-brainer. The statute doesn't contain a definition of national security, which allows Commerce to invent a definition of national security every time it conducts a 232. That's, I think, obviously problematic, but also it seems that this should really be in the purview of the Department of Defense. We include a national security definition that it's pretty flexible, but essentially it bifurcates national security from general economic welfare, which is one of the problems with the statute right now. There is this vague language, which the Court of International Trade cited in its opinion, saying basically allowing Commerce to consider the health of domestic industries and in specific industries and employment and jobs. We also strike that language because it's overly broad. And then the real heart of the bill is the approval resolution. So this basically says that if a president wants to impose 232 tariffs, he has to come to Congress and ask for permission to do so. And so an approval resolution would basically have to be passed through both chambers, and the president would have to sign it in order for 232 tariffs to go into effect. If the approval resolution fails in either chamber, doesn't get a majority, then tariffs never go into place. And it's also retroactive, so it would require Congress to vote on any 232 tariffs imposed within the past 4 years. We did that just to make sure we capture the steel and aluminum tariffs, but it would also apply to autos, uranium, titanium, depending on where, titanium sponge I should say, depending on where those investigations lead. I think the approval mechanism is the biggest point of difference between the Toomey proposal and the Portman proposal. The Portman proposal contemplates a disapproval resolution, which we do see as a step in the right direction for sure. But the 232 statute already has a disapproval resolution in it. It's just for petroleum. And I think Congress put that in place after there was a dispute over 232 on petroleum. Congress did try and use that disapproval resolution before. It's not privileged, so it never got anywhere. And they actually had to attach revoking I think it was a licensing fee for petroleum to the debt ceiling hike. So I think that illustrates the problem with having, a non-privileged disapproval resolution. Is that it's basically the problem we have now, whereby the president can unilaterally impose taxes under 232 on American consumers, and then Congress is kind of stuck trying to find the political willpower to overturn that and get it through the revenue committees and get it on the floor and then override a veto every single time. The approval resolution flips that power dynamic so that the president has to actually come to Congress first and say, this is why I think we really need these tariffs. This is why national security, why we should tax your constituents, because the national security benefits are, so strong, right? And then you would need the House, the Senate, and the president to all concurrently agree that tariffs are a good idea. I think just even having that check would help the executive kind of rein in the scope of a 232 to what is, absolutely necessary for national security purposes. And then I should also just add the approval resolutions are privileged, so the president is guaranteed floor consideration for his proposal. So that's kind of the lay of the land, and as I said, Chairman Grassley has been pretty, I think he's been pretty vocal on this issue. He was pretty instrumental in getting the 232 tariffs removed on Canada and Mexico, which we were really happy to see, but that doesn't fix the problem that we still have tariffs and quotas on allies like the EU. We have quotas on Korea, New Zealand. It's a very small amount, but they're not happy with us. Japan. It's every country. So I think there's still an impetus for doing something on 232. And given the fact that the president did agree that autos are a national security threat, even though that was punted down the road a little bit, he did actually concur, okay, cars and auto parts are a national security threat. So that's still looming out there. So I do think there's still momentum for Congress to really rein in the scope of the statute. And we've been having discussions with Chairman Grassley's staff. I know Senator Portman's staff has been having those discussions as well. They're still kind of working out details of the bill. But Chairman Grassley has said that he envisions more of an approval resolution mechanism with some type of runway before Congress votes on an approval. And then the bill would presumably also shift power to DOD, which Portman's bill does as well. I think most people agree on that. So again, the details are still being hashed out. I think retroactivity is still up for debate, like whether or not it's going to apply to steel and aluminum or just cover autos or just be prospective. But we're continuing to have those conversations, and we've been picking up co-sponsors as well. We actually have 16 co-sponsors total, 8 Republicans and 8 Democrats. So it's been a really bipartisan exercise. We have everyone from like Senator Lankford to Senator Murphy, people you don't really see on bills together all the time. So we're excited to see where it's going. We have 64 endorsers, many of whom came from NFTC. So thank you, Vanessa. And it has a good amount of support. So depending on how volatile the trade landscape continues to be, I think that Congress will want to pick up the pace on reining in the executive a bit.
You have hearings scheduled for that?
Not yet, no.
So what's the situation in the House?
So there is a companion bill in the House. It's Gallagher and Kind. Gallagher is the lead, and then Kind is also the lead on the Portman companion in the House. So presumably whatever happens in the House will be, Ron Kind will probably be leading the charge, which I think makes sense. He's on the Ways and Means Committee. He's really vocal on trade issues. I mean, it will be a revenue measure, so I think it does have to go through the House first. But I do feel that if the Senate Finance Committee moves something, that will put a little bit more pressure on the House, because then they'll also see that there is potentially Republican support for reining in a Republican president a little bit on trade policy.
Right. And how about the president and his ability to veto such legislation?
Yeah, no, we would need a veto-proof majority, and to his credit, I mean, Chairman Grassley has acknowledged that. He said, his goal is to get 67 votes on the Senate floor, and so we want to work with him to come up with a compromise that will get us there. But I do think that it's worth fighting for the approval mechanism, because I think although the president's probably more likely to veto a bill that has an approval resolution in it, that's one veto we have to override, versus with disapproval, we would have to override a presidential veto every time Congress tried to employ the disapproval.
And would you say the retroactivity or going back 4 years is more in play?
I think that's really up in the air. Right. I think that's going to be the toughest part, is how to deal with the retroactivity.
But the retroactivity doesn't change the tariffs that have already been paid. It would it's a sort of limited retroactivity as I read the bill. That is.
Well, ours refunds importers, but.
Yeah, and there's another thing is if, well, legislation would be different, but importers could protest the liquidation of the entries.
Yes.
If you have a successful outcome in the litigation, then they could get their money back. Yeah. Right. Okay, so let's turn to the WTO and Mark. I think we're doing pretty good on time.
Yeah, we're good.
Yeah, okay. So several countries, namely China, the EU, not a country, but Norway, Turkey, and Russia are challenging 232, the steel and aluminum tariffs, right? Canada and Mexico also challenged it, but they withdrew their challenges with USMCA. Please tell us about this, this challenge brought by these countries. Apparently it involves Article 21 of the GATT. It's a national security exception in Article 21 of the GATT. So tell us about it. You know better than I do.
9 countries have sued the United States of the WTO over Section 232. It is a shame that Canada, as part of a compromise, has dropped its litigation, because unlike the other 8, Canada's case was an as such case. And that meant that, much like some of the domestic litigation, there was an effort to curtail the action, not just to curtail the transaction, which would have been very illuminating, shall we say. The issue with respect to Section 232 legal challenges is the expectation that, as an affirmative defense, the United States would invoke GATT Article 21. GATT Article 21 is the national security exception that follows GATT Article 20, which lists all the other exceptions. At one time, they were all under one heading in the original drafting, but they were ruled to be sufficiently different that they each got their own article. And of course, the only reason that 232 garnered such widespread interest was the expectation that on the defense, the United States would use as an affirmative argument that GATT 21 was the reason it could be forgiven for otherwise illegal actions.
Mark, can you tell them what it's an
exception
that's right. from?
So GATT Article 21 is this little bit of text that no one really had a feel for until recently.
Like so much.
And it really isn't just because of Trump. The first case to ever hinge on GATT Article 21 is the DS-512 case, which is Russia traffic in transit. What Russia did in a case that was filed by Ukraine was Russia argued that, sure, it was harassing Ukrainian exports that were crossing Russian territory en route to Kazakhstan, but hell, we're in a state of near war, and Russia invoked GATT Article 21. This was our first chance to see the WTO rule on GATT Article 21, and in DS-512, the panel really impressed on one fundamental term, and that is the panel decided that whatever was meant by either a national security emergency or an emergency in international relations, which is the wording, that is, whatever it might be, a knowable, observable fact. Now that was shocking because the US as a third party in this case argued that GATT Article 21 was entirely self-judging and was off limits and no WTO panel should tread on this terrain. The panel did not take that advice. It ruled definitively that the case was something that was within the reach of the WTO and ruled that it was an observable fact that was empirically falsifiable. That said, the panel was convinced that Ukraine and Russia are in near state of war conditions. That allowed the panel to really skip the hard analysis. Fortunately, we have two other cases in the works, neither of which involve the United States. Qatar is suing the United Arab Emirates, and Qatar is suing Saudi Arabia. In both cases, we are going to get a real workout on GATT Article 21, especially in DS 526, which is UAE and Qatar. That involves an awful lot and is clearly because UAE's argument is Qatar sponsors terrorism and doesn't like Al Jazeera. So the argument will have to be that is near a state of war, which will never pass. As a result, we're going to learn a lot from DS 526 that we did not learn in DS 512. The Saudi case will get going shortly, and that involves not only goods, but services and intellectual property. So there is a GATT 21 equivalent under services, under GATS, as well as under TRIPS for intellectual property. We're going to learn an awful lot, all of which is to set the stage for Trump could never clear the bar that has already been set on the national security exception by virtue of the fact that clearly we are not near public disorder, nor are we in a state of war with Canada, with Mexico, with the European Union, or almost any of the other countries. And keep in mind, China is only 6% of supply of US steel and aluminum. If only Trump had used a safeguard and avoided all of this, but he didn't. And as a result, the other part will come with DS 526, which is the case law under GATT Article 20 will become more relevant because, believe it or not, everyone, this case is going to hinge on three words. It considers necessary. The question is that one phrase or two? For those who like the national security exception, it's one. It considers necessary as entirely self-judging, and once you clear the bar on national security, you can do more or less whatever the hell you want. However, if correctly, it is interpreted much like the EU third-party submission in DS 512 as being, it considers as self-judging, but necessary is not. Then we've got some real play. And in the event that Qatar loses, the global economy, dare I say, is in serious trouble. My biggest fear domestically, as I think the three speakers have already hinted, Trade Promotion Authority will never work the same way again, domestically. But internationally, the genie's out of the bottle. And this national security exception, if it is not struck down or at least curtailed by virtue of DS 526, the global economy is in serious trouble.
So what do you think the timing is of all these cases, and then also consideration of the challenges of the US law?
DS 526 is going to the second round litigation before the panel. So timeline is, well, as we all know, the appellate body will cease to function in December unless the US starts unblocking appointees. I can't really give a timeline given that one fact, but the reality is that whatever the verdict is by the panel, it will be appealed. And Ukraine has decided not to appeal DS 512. So that is interesting in its own right. But what this means is that we may have a bit of a pause and we may have a little bit more latitude in countries wanting to play GATT 21 in the near term until we get an appellate body verdict on DS 526 and then subsequently the Saudi case.
So we may see, I guess things will be unresolved if the appellate body crisis is not resolved.
We've seen a lot of delays in appellate body rulings by virtue of the sheer complexity of the case at hand. If aircraft can push the appellate body to take a little bit longer to release a ruling, I can only imagine what DS 526 on appeal is going to mean. So absolutely, this could be sometime before, and if the appellate body is not replenished, it could be even longer.
Okay, let's,
Can I ask Mark
go
a question?
ahead, go please.
Excuse my trade ignorance, but what remedies are available? That is, what would happen if the WTO found that there had been a violation of the GATT?
So in that case, the 526 example would mean that Qatar would presumably ask for authorization to retaliate against UAE. That would mean that Qatar would be drawing up a retaliation list with 100% tariffs, suspending concessions, meaning violating MFN, which is now very much in vogue, it would appear, and then we would be off to the races at a set volume. Unfortunately for Qatar and its neighbors, the WTO will be hard-pressed to come up with an answer that will satisfy the broader foreign policy issues that are being played out. But they made it a WTO case, and that's where we are going to hear at least this side of the story. For a remedy, though, the WTO is probably not the venue in which ultimately Qatar would seek redress. And since Ukraine is not appealing, clearly that's not going to work. But in the event that the Section 232 cases did go the full distance, and to the extent that anyone is left after some of these side deals, minus China, to follow through on authorization to retaliate, then again, add that to the 301 and add that to the other skirmishes, and we've got a real situation.
But from the perspective of the people who paid for the tariffs here in the United States, they don't get, no matter how favorable it is,
that's right,
they don't get anything out of it. Good, because I'm afraid that some judge is going to ask me that question sometime, and I'm glad to know what the
You're
answer
ready,
is.
you're prepared. Yeah.
Prospective compliance, no retroactive
Got it.
damages.
Thank you.
So Article 21 allows, if they accept your excuse under Article 21, that there's a national security emergency, the country can harass other countries and impose tariffs, like what we've been doing. Is that's the exception to
The interesting question is that word necessary, because GATT 20 case law says that necessary means there's some nexus between means and ends. So now all of a sudden, if you believe the word necessary is separate from it considers, there has to be some establishment that in pursuit of a certain level of national security, the means are fulfilling the ends. And that would be hard to do in all of these cases, because there are always exceptions. And ironically, the one big exception right now between UAE and Qatar is that there's an embargo on everything from and to Qatar except one thing, gas.
Okay.
And that's the single biggest item traded between the two.
Of course.
So Alan, I just want to ask you, going back to the litigation, you know, the Supreme Court's about to make a decision whether it's going to accept the case and review the CIT's decision. What do you think the chances are? I mean, what's your feeling?
I'm a litigator, not a bookmaker, and so I don't have any feelings about it. Certainly, we presented a case that's so compelling, how could they possibly turn it down, except that they do that to my cases all the time. So I don't feel very confident about my judgment on this. I'm probably the last person you should be asking about that.
Well, you sound so
but we've been very helpful with our amicus briefs, and that's always, I mean, my client is an association of little guys and workers and unions and port authorities and transportation companies, and so having the NFTC on our side is a big help to us in that regard, and also having the farmers. You talk about the trade, the net thing that they've now, it was $12 billion the first round, and I think it's another 16 now, and so. Quite apart from the legality of that issue, which nobody really can litigate because nobody's got standing, it surely, even at $7.5 billion for tariffs, that doesn't add up in my book.
Well, I think we wouldn't have filed the case if we thought it was frivolous. I mean, these cases cost money, and our members were willing to stand behind the case. I think we did it for two reasons. One, we think there is some interest in the court. We know from some of the justices' writings that there's some interest, particularly among the new members, in the non-delegation doctrine. So it's actually alive and well in terms of we know the justices are thinking about it. But the second reason was we wanted to send a message to the administration. You know, this is a situation that is rapidly spinning completely out of control. And American businesses are taking a hit, and American consumers are taking a hit, and our members are willing to be on the front line and say this is just not acceptable behavior. You can see from looking at the history of 232 that this is not the way any of previous administrations since 1962 has construed this law to apply. And we think the reading that the Trump administration has taken of the law is radical and needs to be addressed by the courts.
So there have been several 232 investigations done by the Commerce Department, titanium sponge and uranium, and the most notable one probably, other than this metals investigation, is autos and auto parts. And recently the president did make a determination that imports of autos and auto parts did constitute a national security issue. So any thoughts about his finding, and whether you think this might impact the litigation or the legislation?
Well, Vanessa made a point earlier about the Department of Defense. We know that in the steel and aluminum case, DOD wrote a letter saying, we don't think there's any problem. We got all the steel we want. We don't think there's any national defense problem. And of course, that doesn't matter in this case because there's no court that can say, wait a second, how could you conclude this if the Defense Department says that? That letter was released only after the Commerce Department recommendation report was released, and that occurred a month or so before the president issued his determination. We haven't seen the Commerce Department report on
if anyone has it.
What's that?
Share. I said, if anyone has it, feel free to share.
Yeah. And so I would expect we wouldn't see the Defense Department response.
I think we will never see it, correct.
Well, you could make a FOIA request for it.
I could make one, but we won't get it. Deliberative process.
Maybe. Not required by law, anyway. So, as far as, I mean, in my view, as a constitutional matter, I don't think it matters very much. I think had the president actually imposed tariffs on autos and auto parts, it would have raised the stake and made it more likely that the court would have granted review. But if the court grants review, since it hasn't done that, we didn't mention it in our last filing because the connection is too complicated, and we will probably mention it because it would be a small fact if we get to the merits. But I don't think it has much to do with the constitutional argument. It does suggest that the problem is bigger, and that, of course, in terms of the constitutional challenge, is always better.
Well, while you didn't mention it,
we
presumably, you mentioned. It's a good thing you mentioned it. Maybe do you think it might influence?
Well, you didn't, because the president hadn't actually issued
I filed my brief before the
yes,
announcement.
Yeah.
No, I think. Let's be honest. If you look at the size of the automotive industry in this country, automotive tariffs and auto parts tariffs would dwarf the steel and aluminum tariffs. It's like a tenfold size difference in terms of the number of companies that are involved. So, I think we did mention it, and I think if we get to briefing in the Supreme Court, it'll be even closer to November 17th. We'll be even more, closer to that time frame that he said he's going to make a decision about auto tariffs and auto parts. And I think from the perspective of a national interest, it would absolutely be something to raise it if we get before the Supreme Court in terms of the amount of harm that could be inflicted.
And that's the advantage of having an amicus briefs, that they can point up to those things. There are serious word limits on how much you're allowed to say, and so we would probably prefer to have it come from an amicus and have us focus on the legal constitutional arguments.
Just to clarify, for this, your only shot to get Supreme Court review is the briefs, right? You don't get to say anything?
No. That's it now.
That's it.
On the other hand, if the president did something, we could always, if the president imposed on auto parts now, we could file a supplemental brief that would point that out to him. Yeah. But there's no argument or anything, oral argument or anything like that.
Well, can I say a few words on the auto?
Yes, we want to hear what you have to say. Sure.
And I think that, well, he could impose. I know he delayed 180 days, but he could impose auto tariffs at any point within that period. It's totally up to the president's discretion. But I think, I don't know how many people have actually just read through the proclamation where the president says he agrees with Commerce's affirmative finding. But some of the language is really interesting. I think the whole exercise around auto and auto parts being somehow a national security threat when the auto industry is doing very well right now just kind of begs the question, like, who is safe from a 232, and shows how broad the statute is, right? Because if you read the proclamation, it's very focused on how do we increase R&D investments that are made by American-owned auto companies, GM, Ford, Tesla only. Even though domestically, I think, and this includes the global automakers, but the auto industry invests like $19 billion a year domestically, which is more than the budget of NASA. So I would say that their R&D investments are pretty solid. But if they're very focused on R&D because, you know, autonomous technology that car makers are developing could be used by the military, for example, well, why aren't they also, you know, going after Google and Apple and Uber that are all also developing this technology? I mean, where does it end? So
It doesn't. That's the problem.
And they also, like, you know, take a number from 1985 for vehicles produced and sold in the U.S. and compare it with a number from 2017 to indicate a contraction in industry. And it's like 1985 was before NAFTA, before, you know, the auto supply chains became fully integrated across the North American continent. So I would just, it's just a very odd intellectual exercise in my view.
Can I make a point about that? That is, all these logical arguments that show how silly and unprincipled these determinations are, and the Defense Department doesn't agree on steel. None of those matter under 232 because the president can do whatever he wants and he doesn't have to justify it to anybody. And that's really what the legislatures do. They don't have to justify. They can make determinations, but we're protected because there are two houses in the president that have to agree upon it. And that's the protection that's not there with statutes like 232.
Right. So, Haley, if the president has kicked the can down the road for 6 months, so before you know it, it will be there in 6 months.
Oh yeah.
If he does impose tariffs or quotas, or do you think the momentum, you know, there will be more of an impetus to get the legislation passed?
Yeah, I think that's the reality of it, right? Like, obviously, we don't want to see tariffs and quotas go into effect on autos and auto parts, but if that were to happen, I think you'd see Congress, hopefully see Congress act right away. I mean, we're witnessing pretty unprecedented levels of trade protection across, you know, we have tariffs now on half of our imports from China. The 5% tariffs were announced on Mexico under IEEPA, and then we still have the 232 on steel out there. If this isn't the straw that breaks the camel's back, I don't know where Congress is going to be willing to step in. So, again, we don't want to see that scenario play out, but I do think that would push members of Congress politically. Because there are some disagreements in Congress on the merits of steel and aluminum. Senator Toomey's been very clear he doesn't see steel and aluminum as a national security threat, but on autos, everyone's united. I can't point to anyone that thinks auto tariffs are a good idea.
Okay, I want to ask one final question before we open the floor to the audience for questions, and that has to relate to trade negotiations. The U.S. is starting. We're starting negotiations both with Japan and also the EU. How does the 232 situation, especially with regard to autos and auto parts and also metals, how do you think that will affect pending trade negotiations? Maybe Vanessa.
Well, I think the Canadian example is an excellent one. Prime Minister Trudeau had basically no choice but to get the tariffs lifted in order for him to submit the ratification documents to his parliament. And he made that pretty clear. The Canadians had been saying all along that they would not ratify the USMCA without the tariffs being lifted. And I think the primary reason for that was domestic. He had to deal with a lot of domestic discontent among his steelworkers and aluminum workers who export a tremendous amount of metal to the United States. And he knew domestically, facing an election in the fall, that he was going to have a hard time facing his constituents, particularly because his riding is in Quebec, which is where a lot of the aluminum is produced. So I think the answer is that's a cautionary tale. I think the Japanese and the Europeans have said very clearly they don't believe that these tariffs are fair. They want them lifted. The negotiation, that is an issue in the negotiations. you know, we'll see how it plays out. Both sets of negotiations are in their infancy, I would say, in terms of where they are.
Right, right.
There's a lot, there are electoral politics at play, both in Japan and in Europe, that are going to play out over the course of this calendar year, that are going to make it sort of hard for them to move too quickly on those negotiations. So, but I don't think, and those tariffs staying in place, I can't conceive of a negotiated objective where they reach the end of the road and those tariffs are still in place.
So, I mean, it sounds like you see the playbook being that that the administration will have to remove the 232 metals tariffs to get any kind of free trade agreement passed, just like what happened with
Yeah, but you're assuming that in the next 2 years they'll be able to get one.
Yeah, that's
true. I mean,
true.
I think, you know, trade agreements take a long time. The USMCA was
true.
a really pretty fast negotiation.
And it's a renegotiation.
And it was a renegotiation. I mean, you know, at least in the USMCA, we were starting with sort of an agreement of where we were starting a baseline. In the case of Japan and Europe, we're starting really, you know, pretty much new negotiations. I mean, the Japanese have the TPP. We have that sort of contact with them, but with the Europeans, it's like starting from scratch. So it's a really hard negotiation.
Okay, before we turn to the audience, any final words that any of you want to make? Any thoughts?
This is truly crushing U.S. credibility. My biggest question as a foreign government would be, am I going to watch a repeat of this bad movie? Because the strategy, the art of the deal, as it were, seems to be offer a managed trade deal, unleash 232, throw a lifeline on condition that you promise to ratify, and then call it a day. But what we've seen, and I wouldn't want to underestimate the acumen of some of these other governments, what struck me most about the fall in Canada was that what Canada did to get through to USMCA was pretty much to give the US what it had already given everyone under TPP. So I'm not sure that we're any longer focused on the deal as opposed to the art. And I worry that the art right now is literally trumping the deal in a way that is not positive going forward. And I have to imagine that this new wrinkle whereby USTR is expressing concern about trade deficits with the European Union and that as being a TTIP cautionary tale, none of this bodes well. But one has to wonder, especially for Justin Trudeau, who will lose in the fall, what are the incentives for me to engage with this at a time when these 232 threats come from anywhere at any time over anything, and at a time when your average car crosses the US-Canada border 7 times in production? What are we doing? And maybe the idea becomes you wait this one out and that no one entertains serious negotiations until some other time. But again, anticipating your next panel, my biggest fear out of all this, because in steel and aluminum, life gets ugly every couple of years. But my biggest fear out of all of this is that Trade Promotion Authority is dead. You will never see that delegation to the executive for the purpose of, much like the Reciprocal Trade Agreements Act, getting a little more trade and a little less politics into a vote on a clock. I really fear for the future. And I don't know that any president of either party next will be able to unwind some of this damage.
And last week's 5% tariff, that gives you even less enthusiasm?
Well, that's
Very scary stuff.
And that's another tool. This is the third tool.
We reach a deal, and by the way, then we're going to use this other tool, which we didn't cover in the deal.
Right. So I think that's pretty problematic. I must say one thing, I must mention one thing that I forgot. This panel was operating under Chatham House rules. Okay.
So you can't quote us.
It's like the dinner, you know, like there's always something you forgot to put on the table. Well, I forgot the Chatham House rules. So just want you to know, and that means you can repeat the information, but you can't attribute it to an individual or an organization. But I thank you very much. But let's, any questions? No questions?
We've been so clear that we've clarified everything.
Yes, gentleman over there. And there's a mic, right?
Line up there.
So we can
Yeah, line up over there.
Line up behind the mic. Yeah. You can do one at a time.
So this is a question for Ms. Craig. Given what the president announced last week with regard to Mexico, is there any possibility that any legislation to deal with the president's authority in 232 could be expanded to include this International Emergency Economic Powers Act? Because Senator Grassley said that that the president's announcement was a misuse of presidential tariff authority? And if so, how would that sort of complicate any efforts to get any legislation through?
Right. No, it's a good question. So what I was also encouraged by in Senator Glassie's statement was that he said it was counter to congressional intent when we originally passed IEPA. And part of the reason that IEPA was written as it was to rein in the Trading with the Enemy Act, and now we've seen that this has become misused, right? I think that Senator Toomey on 232 is very focused on keeping his bill exclusive to 232, and I don't know if it's best to deal with these issues separately, but I do think that if the president moves forward with that 5% tariff on June 10th, you're going to see some type of reaction in Congress. One thing that I should point out is that the president has to declare a new national emergency in order to invoke IEPA. Even though he has already declared a national emergency related to the southern border, he did not invoke IEPA. He invoked other emergency powers, so he has to actually declare a new one. And that would potentially be subject to an expedited congressional disapproval, just like the most recent national emergency. So you could actually see a congressional vote on the 5% Mexico tariff just because he has to declare a new national emergency.
But it's not binding unless the president signs it.
Right.
So
you would need veto-proof majority.
But
he
yes.
could veto
Yes.
it.
Right.
But if the Congress were willing, you could certainly attach an appropriation rider to the appropriations bills and/or the debt ceiling, which I think is coming up this summer, or something else that the president really wants. It's all a question of will. It's not a question of power, because they've got some tools to use, and the question is whether Congress is willing to do that.
So, I mean, from what you both are saying, Congress has tools to deal with this use of IEPA, which you said, what Senator Grassley says is a misuse. If it's a misuse, I would think that you should have a pretty strong case in litigation.
Well, first place is
We may find out.
Yeah, yeah, and there's
first thing I
I'm
would
not
say
gonna say anything
is there is no executive order yet.
yes, I know.
So
and there's-
we don't know exactly what he means.
Unless it came out in the last half hour.
well, yeah, never know.
Does it include what tourists bring back? Are there any exemptions? Who's going to enforce this? How are they going to set valuations on things? And what mechanism are going to have to do this? This is not like steel imports. These are every single thing, at least according to the announcement. And second is, until you know that, you don't know who is going to be injured and what kind of standing there is, and whether, presumably, the government would fight us on that. We had a lot of standing in this case, and it was around for a while, so we knew what was going on, and they didn't object to our standing, which is quite unusual in and of itself in government litigation. And then they will make all kinds of arguments, as they did in the border case, about standing and who's effective and what they're doing. And so it could be tied up for quite a long time, and it would be much faster for Congress to slap a rider on like they do with the District of Columbia almost every day. And we could see it happen that way.
But once, we have to wait for a presidential proclamation or, the executive action for it to become real. Right now, we just have a tweet, but he seems to be insistent.
We have a date.
We have a date, that's true, which happens to be my birthday, but,
Which can be extended at any time he wants for any reason he wants.
But they have to give Customs a few days to reprogram all the...
Right,
So
right.
they have to issue something by like Thursday, or there won't be enough time to have it actually be effective on
June
Sunday night.
10th, which seems to
So
be...
watch for Thursday.
Watch for Thursday, okay. So, but there will be people who are affected. They might use like an exemption for de minimis, like
No, I think that people,
$800 probably,
there'll be, once the measures in
But-
place.
Yeah, that's right.
But
They'll have
as,
ways, yeah.
as I know you know, people are not anxious to sue a president who retaliates against them.
Right, that's true.
And he is a retaliator. We know that.
Right.
And fortunately, in our case, we had a trade association of 120 members, and they felt insulated from in some respects, considerable respects. But there are not going to be a lot of people who are going to want to come out and stick their neck out and be subject to the president's tweets and other conduct.
Okay, let's take the next question.
I was wondering if you could provide maybe a synopsis of what the U.S. is arguing in the case AIIS versus the U.S., and also if there's been any response to the economic arguments that you've offered, Is it just that national security is within the wheelhouse of the executive and some other things like that? What are their main arguments against you?
Well, first thing is, if you go to the U.S. Supreme Court's website, all of the documents are online, so you can get them actually there. Or if you give me your name, I'll send it to you. But the main argument is this Algonquin case controls, and therefore the court doesn't have to reach it. Second is they say that everything the president does was within the statute, and that this statute is no different from all of these other statutes that the court has upheld over the years. We think they are considerably different, in part because in every other statute you could see where the boundaries were, and they've been unable to point to a boundaries. We have not argued the economic impact in our brief, because that's not what the question is. Our question is it constitutional? So while there's an aura of economic irrationality about this in our brief, that's not the way we're attacking the argument, because that's not within the scope of what the court can do.
But we raise that in our brief because we're trying to convince the court that it's a case of national importance. So that is a relevant consideration for the justices. They will consider whether the case is significantly affecting U.S. individuals and U.S. companies. So that was what the Amicus briefs were largely focused on.
And has there been any Amicus responses to you specifically? Or
No.
No.
The American Iron and Steel Institute filed a brief in the lower court saying this was good for the steel industry. Big surprise. And they have not come into the Supreme Court, although I expect if review is granted on the merits, they will.
We'll see them in the fall. Yeah, if this goes to the Supreme Court, there'll be a lot of other.
But that's not unusual. Yeah. You generally don't see amici on the side of saying, we agree that this case is not important enough to be heard. That's why we're spending all this time and money telling you that. Yeah. That just wouldn't what happens.
Right. Thank you.
A recent article noted that more people are moving to Mexico, including American citizens, than Mexicans are moving to the U.S. The immediate reaction to the announcement of 5% tariffs going all the way up to 25% has been a devaluation of the peso, which can be very harmful to Mexico's economy. Mm-hmm. You mentioned other harms that can happen. Businesses whose volume of businesses is reduced by tariffs. Can you also mention the other economic harms that can happen not only to Mexico's gross domestic product, but also the American domestic product as a result of these traffic impositions?
Well, I think your brief talks about that.
Yeah, not only that, but in the case of Mexico, so picking up on Mark's point, if you've ever seen, there's some really good infographics that show how many times auto parts go across the border between U.S., Canada, and Mexico, and a carburetor can cross the border like 6 times before it's fully installed into a vehicle. The North American economic footprint is very integrated, particularly in automotive trade, and the effect will be felt immediately. Ironically, there are a lot of U.S. investments in Mexico, which will be on the they'll be on the receiving end of this as well, because when the U.S. controlled Mexican investments, then when those exports go into the U.S., they're going to be tariffed, right? So it's a very strange, choice, because it not only affects Mexico and Mexico's economy, but it's going to actually affect American investment in Mexico, which has been a very successful partnership between American companies and the Mexican economy. So it's a very tragic decision by the president to impose this kind of a tariff. Right. Not affecting the Mexican government necessarily at all, affecting people and companies and individuals.
Well, I was just going to add that the nature of trade between the U.S. and Mexico is different than the case of the U.S. and China, right? Because a lot of, as Vanessa alluded to, a lot of trade that happens between the U.S. and Mexico is like intra-company. So a company sending auto parts across the border, for example, which is, I think qualitatively different than having one component coming, from China. So that's going to be, and a lot of it's, just-in-time manufacturing as well. So it can really jam up supply chains pretty quickly.
The bigger picture, though, here is quite aside from any volume of trade in steel, aluminum, or titanium sponge, this 5% announcement escalating to potentially 25%, it goes to the very fabric of today's global economy. It is potentially going to undo our understanding of what Article 23 of the Dispute Settlement Understanding had clawed back. And the shock is that somehow we're surprised that this president has rediscovered tariffs as a form of central budget revenue. It is stunning to realize the 1930s mentality. The day the United States signed the WTO agreements, it forwent 13 billion US dollars in tariff revenue. There's nothing new here, but in the marketing genius that is the current moment, tariffs are no longer taxes, they are the fee to pay for entering the amusement park that is known as the US economy, and somehow we are going to get rich by doing this. If we can do it, they can too. And the idea that we will now be witnessing the emergence of beggar thy neighbor trade wars, congratulations to us for rediscovering the 1930s for real, because that will be the end result of this game. There is nothing elusive about tariffs as central budget revenue generating, but the fact is that we made a deal because we knew it was Pareto inefficient in the long run, and now we're reneging, and that is far worse than any commercial trade flow per se, steel, aluminum, or anything else. We are completely jeopardizing an equilibrium that was hard fought to begin with and potentially could never be restruck again.
Well, it's worse than that even, because it isn't even raising revenue for us.
That's
when you're bribing the farmers to not pick on you
billion.
by giving
The
them
transfer of wealth, it's all okay. It's all okay.
I call it a bribe.
We're just saying for farmers because that's a good thing.
Right. There was a Wall Street Journal article today about how companies have moved supply chains from China to Mexico.
That's the worst story.
And now
that kills me. My companies that did that, they're just like, what?
Yeah, so what it tells me is that maybe there's a method to this madness, which is we don't want trade. We don't like global supply chains, you know? So I mean, I think.
Well, we saw that in the design of ISDS under USMCA. That was a very cynical clawback of investor-state dispute settlement, all with the intention of raising the cost of doing business in Mexico. So that is certainly what we're getting the feel for.
So there's nothing inherently wrong with that position, as long as it's the Congress of the United States that enacts laws that take that position. We had laws like that, and we got rid of them, as Mark said. And the question is, are we getting them through the back door of 232 and IEPA? And that's the question that we all need to address.
Okay, with that, we'll close because we have a guest speaker, an intermission, and which is a surprise, and a second panel. So please thank our speakers.
Thank you. Yeah, very good.
Okay, thank you so much for this thought-provoking analysis. Lot to be learned and a lot of takeaways from the discussion. So while you move off the stage, I will call to Ms. Andrea Durkin, who is going to be presenting a little presentation about her initiative, Trade Vistas. She is with the principal of the consulting firm Sparkplug LLC. And Trade Vistas is a website that offers facts, contexts, and stories, resources on trade. So that's going to be the next on our program. So Andrea, thank you.
Hi there. So I'm not going to sing and dance as part of the intermission, but I just wanted to thank everybody for the opportunity to tell you, while they get ready for the next panel, a little bit more about Trade Vistas. My name is Andrea Durkin, as was mentioned. I'm the editor-in-chief of Trade Vistas. We've been around for about 2.5 years. We're a nonprofit educational website. And we started Trade Vistas nearly 3 years ago, before trade was in the headlines every day. And even then, we felt that most Americans really didn't know enough about trade policy to make informed decisions. And even today, with trade in the headlines, Gallup recently reported that nearly 6 out of every 10 Americans say they don't know enough about trade practices and trade policy to really make an informed decision about whether global trade helps or harms their daily lives. So what I'd like to do is, instead of just talk about it, show you a little video clip of some of the work that we do. you. So really what we strive to do is to offer a clear view on trade. We're trying to tell stories in a very straightforward, understandable set of narratives and connect global trade to our own lives and our communities. And I can show you just a little bit about the website itself. We like to joke that we see trade in everything. We're nonpartisan, we're not advocacy, we're just looking for average stories out there to help make trade policy relatable to our own lives. I joke about this. I was doing a little bit of paint by number, and even there I thought, well, I'm going to do a little research on paint by number, and found that there was a significant anti-dumping case on paintbrushes from China, and wrote a story on that and got a lot of email responses. And it's just a way for people to kind of connect to trade policy and sort of reel them into the more detailed, deeper stuff that we deal with every day. So what we find on the site here is we push emails out every week just explaining what we've put, what's new on the website. And you'll see here at the top of the homepage, you've got our latest thinking and featured stories. We've recently reorganized our website to make sure that you can easily find topics that are trending, like NAFTA, Brexit. Obviously, you can see this chart over here was contributed by one of the speakers, Christine McDaniel, you're going to hear from next on the tariff exclusion requests and their impact. We've reorganized the site so you can easily find things by topic. We also have everyday trade articles. These are two of my favorite topics, chocolate and beef. And again, if you have ideas for stories, we are happy to write on just about anything and explain trade through things that we know about and care about and use in our daily lives. We have a technology page as well where we explain the impact of technology on trade, jobs, manufacturing, the fact that the way we trade on a daily basis is changing through digital commerce, and what is the impact of that, and how do we protect our innovative ideas through trade policies. We also delve into unfair trade policies like industrial subsidies and some of the heavier topics, and include essentials like trade institutions and trade negotiations. We have made a conscious effort to produce videos, which are very popular on Facebook and social media, and we push those out, and we love for people to share those. We've also worked to produce original infographics, timelines, and interactives to explain what's happened, for example, in the US-China trade war over the last 2.5 years. Those are all intended to be fully shareable and usable, and particularly since we're here on a university campus, we really are trying to reach the student population and kind of the next generation of trade thinkers and trade policymakers. So please feel free to check out those articles, check out the infographics, share them. We've tried to make it extremely easy for you to share it on whatever medium is of interest to you. And lastly, we have a newsletter that we push out every week, just telling you what we've been publishing and what's going on the site. We have a few different sort of data points and infographics we share just through the emails and not necessarily on the site. It is totally free. It is funded by the Heinrich Foundation, so sign up. And please do share your thoughts because, as I said, we're always looking for ideas for stories, and we hope you'll check out the site. So get ready for the next panel. I'm looking forward to it. The last panel was great, and this one's going to be even better. Thank you so much for your time.
Okay, thank you, Andrea. It's now time for our second panel, collateral damage and unintended consequences. I would like to invite the speakers to the stage. Our moderator for this panel is John Saylor of Commonwealth Trading Partners. Please join me in welcoming John and the panelists.
Well, first of all, I want to thank the panel that was before us because you set us up. And as you can see by the program, we're covering collateral damage and unintended consequences. And it has been explosive, to say the least. And some of the comments that were made in the previous panel sort of touched on that, but we're going to go in deeper. First of all, want to talk about, I am from the district export councils. Besides that, Anna said I'm with Commonwealth Trading Partners. I'm the director of International Trade Group. I have been doing trade for over 40 years. I've been in 90 countries. I've handled everything from cigarettes when I worked for the tobacco industry, so we hit just about every place, but engineering companies, so it's been products and services around the world. But as a former chairman of the District Export Council, Virginia, Washington, D.C. District Export Councils, the DECs I was appointed by the Secretary of Commerce. I still am appointed by the Secretary of Commerce. I go back to probably one of the longest serving members on the DEC. I go back to the 1990s. There are 61 district export councils in the United States in every state. Some states have more than one. Our district council here is Virginia and Washington, D.C. There are over 2,000 members, mostly SMEs, but we do have some large corporations. So we are instrumental. Right now, I do a lot of work for the DECs because I'm here in Washington or here in Northern Virginia on a lot of policy matters, and I've been doing this for years. I personally have worked on 8 free trade agreements on previous administrations, and currently I'm involved with the USMCA. There is a coalition that's been put together by the Business Roundtable, the U.S. Chamber, National Association of Manufacturers. We have about 400 members on this group, mostly associations across the country, covering every possible commodity you could think about. And this coalition came together several months ago when the White House finally reached out and said they're going to need help to get NAFTA 2.0 passed, which is now it's the USMCA. So I have to tell you that in the last several years, since the president came into office, I asked the people at the U.S. Chamber, and you all know where the U.S. Chamber, right across from Lafayette Park, has anybody from the White House reached out to you to talk to you about trade? No, nobody. To me, I found that shocking, considering that the Chamber has always worked closely with the White House. So it's just been recently that we've been meeting. We have a meeting on Wednesday, which I think is going to be exciting. We usually get about 60 or 70 people over at the Business Roundtable to have a discussion. But one of the discussions we've always had, it seems to come up, is the number one issue, the number one fear that we have as we try to work Capitol Hill and get members to go ahead and push this, is something that the president will say and do. So Thursday, our panel, we had a conference call to talk about how we wanted to do this. And we decided, let's not set anything hard, not a set agendas, set questions, because we have no idea what may happen between Thursday and Monday. And it was an hour after that phone call when the word broke of what President Trump did. And all of us, we started messages going back and forth, going, oh my God. So I have to say that, you know, all I can say is that the President Trump is the gift that keeps on giving. I shout out to the President. I know he's in the UK now, but I want to thank him for helping our panel today. It's been very nice in doing this. I also want to thank Evelyn, because we started, what, 3 months ago? Anna and Evelyn, we started 3 months ago. So Evelyn came up with the topic. And I said, Evelyn, I'm not sure if this is really going to work. Can we really attract anybody? You know, and as this was going on and came up with these topics for the panel, who knew? Who knew that here we are Monday, and it's only been that's all it's been across the news, day in, day out, trades and tariffs. And the consequences of what's going on. Mark, you hit the button, you know, right on the nose when you talked about, you know, the damages this can be. I'm getting a flashback. In 1991, I was in Kuwait. I was there on behalf of the Kuwaiti government, who was in exile here in Washington at the time, a week after liberation, and they took me up to the highway of death. And I was standing there on the Kuwait-Iraq border. This is where we caught the Iraqi army fleeing back to Basra. Behind me was Iraq, and I'm right on the border. It was purely clean desert. I mean, it was just perfectly white, nothing there. Turning around and looking in front of me was a total mass of destruction. I'm a former Marine, I'm a Vietnam vet, but I've never seen anything like this in my life. And I keep thinking about what the president has brought on us. And a lot of this stuff that happened on the highway of death wasn't so much what the coalition did, but it was what the Iraqis did to themselves. This is where we are right now. Last year, well, 2 years ago, in March of 2017, I went to Albania. Trust me, I went to Albania to see the president of Albania as his guest. I was doing advisory work for him, and he brought me in to talk about some security and trade issues that were there. And while I was there, he asked me, his wife asked me, would you mind giving a speech the next day at the university? We have selecting, would you mind giving a speech on trade and security in the Balkans? And how the President Trump looks at trade and security in the Balkans. When I got there, students were all asked me a question. Your president, mine is only 2 months after he's taken office, your president just says a lot of stuff. And it doesn't make any sense, and it scares us. I mean, how are you going to keep him in control? And I said, well, you know, you have to understand how the United States government, we have three group areas of the government, the legislative, you know, the judicial, and the executive. I said, the legislative, with the Republicans there, they'll be able to handle him, they'll bring him back, and they'll take him under control. Well, fast forward to today. We know what happened. So it leaves us a lot right now to guess where we are going and what we are doing. And another point to the previous panel, I know some people I hear may not watch Bill Maher, but on Friday night, he made a good statement. And I mean, he bashes the Democrats as well as the Republicans, but more the Republicans than anything. But he did make a good statement. And he said that these tariffs, these are not tariffs, this is a tax on the American consumer. Just call it what it is. And Friday, which reminds me, I think I was, again, Mark and I were talking about this, PBS had this interview with Peter Navarro, who absolutely, if you saw it, was adamant about, when the interviewer was asking him, you know, this is a tax on the American consumers are going to pay this tariff. He goes, no, they're not. Mexico and China will pay this. And trying to argue, and go, I can't believe he said again and again and again, trying to get this message out. So one of the things which I do and on the Hill when we work on the trade issues, when I meet with members of Congress and their staff, like Mike is he's going to add into this later on, but we always try to emphasize the point because people out in the hinterlands don't know anything about what's going on here. We're really in tuned in it here in Washington. But you go out in some places, they haven't got a clue. They just don't know. And so I always like to bring up this thing when talking about members who don't understand what our constituents, and this is where the president's coming, we don't like trade. We want to bring it all back. We hate trade. We don't want anything to do with it. So I said, excuse me, Congressman, do you have a Walmart in your district? Oh, yes, of course they do. I said, do your constituents like shopping at Walmart? Oh, they love it. I said, you know, like 85% of the stuff in Walmart's imported and about 70% of it comes from China. And if Walmart was a country, they'd be China's 6th largest trading partner. So on one hand, they like the cheap prices from Walmart, and the other hand, they hate trade. You can't have it both ways. You need to go out and educate them. We need to educate the members of Congress, so that's what we're doing. So this brings us to our panel. And how we're going to do this today, I'm going to introduce one member at a time, and they're going to talk a little about themselves, and we're going to go right down the line. And after we're finished, then we're going to open up to questions, because we're in a situation, I've been doing this for like 40 years, I've worked in all these trade, I have never, ever, 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 ever seen the situation we're in right now. And I think that was highlighted clearly by the first panel. So at this time, I have Paul Nathanson, who's sitting next to me here. Paul is a partner in the Policy Resolution Group at Bracewell LLP with more than 25 years of experience in strategic communications, public affairs, and public relations. He currently manages the Coalition of American Metal Manufacturers and Users, a group representing U.S. manufacturers opposed to Section 232 steel and aluminum tariffs. This will fall right in on what we just discussed. So, Paul, would you, a few little words about yourself personally, and then go for it.
Sure. So, thanks for having me. I have a master's from GW, from what was the Elliott. It is the Elliott School. It wasn't. I was before that, but so I'm very excited to be back. So I do strategic communications, as you said, and all sorts of policy issues. And trade was pretty quiet for the last 10 years, and now, you know, if anybody says that you know, when the president says tariffs create jobs, you know, our business is booming, but I'm not sure if there's any other jobs beyond that. But for consultants and folks, lobbyists, it's very busy. As John said, I run a coalition of American metal manufacturers and users, and this is a lesson to you that if you let your members of your coalition vote on a name, this is what you get, Camus. But I think our domain name, our website, and our Twitter handle says it all. Tariffs are taxes, tariffsaretexas.org, because that's, as we've heard, my members are the ones who are paying for these tariffs, are paying the tariffs. And my members include fasteners, metal formers, wire producers, food equipment manufacturers, machine products manufacturers, contractors, even folks who make educational science kits. So my folks are small and medium-sized businesses, mostly family-owned, that have been passed generation to generation. To be frank, mostly voted for President Trump and are supportive. They cheered the tax reform that happened, tax cuts, but fast forward to about, I'd say, September of last year, all the benefits of the tax cuts that they received they tell me, were wiped out by the tariffs, by the price that they had to pay for steel. Now, let me tell you, my guys, really, steel prices are a concern, but it's not the amount, it's not the price that they pay for steel that is the biggest concern. It's the price that their competitors overseas are paying. Because when they pay a lot more for steel than their competitors, my guys make parts of parts of parts. And their customers will just go overseas and buy that part and either import it or they'll lose that customer relationship. So when the other side tells you, well, prices are going down, all steel prices are going down, but around the world, right now there is a difference between the U.S. and China for, this is hot rolled steel, $229 a ton. It's a $179 ton price difference between the U.S. and Europe. I have a guy in Colorado who said, I just lost a project to a company in Austria. He said, that has never happened to me because they could outbid me because of they're able to pay a lower price for steel. What is the, I'll focus on the topic at hand, the impact or the unintended consequences of the steel tariffs. I got a gentleman in Michigan who is, he is a small manufacturer, and he said that he had record sales last year. He did the best that he ever did. And zero profit. It all went to paying for higher steel prices. Keep in mind that my folks don't buy that much foreign steel. They buy mostly U.S. domestic steel because the whole purpose of a tariff is to protect your industry so that they could raise their prices. And that's exactly what happened. I mean, we've been through this before, the 201 tariffs back in 2002 that I was involved in. That cost 200,000 jobs in steel-consuming industries, and we lost 20% of our metal formers, one of our members, because of high steel prices and their inability to compete. So we've seen this before. One other point I would like to make is say, well, why aren't we seeing job losses? There should be massive job losses like we saw in the 201. Well, there's a couple reasons. One, the economy is booming. My folks say, look, I'm doing well, but I should be doing better. And dark clouds are coming because I'm starting to lose out on bids. Some of my suppliers are saying, some of my members are saying, some of my suppliers are saying, look, don't even bother bidding on this project because we don't even want to deal with you anymore because we don't know, we can't predict what's going to happen. We don't like the uncertainty. The other thing that's why we're not seeing more job losses, the last thing that my manufacturers want to do is to lay off somebody because with 4% unemployment rate and a massive shortage of skilled workers in this country, once they lay off somebody, they're never going to see him again. So they're trying everything else before they're going to let somebody go. Just a couple other points, and I'm happy to take questions. The utilization rate, we're all doing this supposedly because the Commerce Department said that the domestic steel industry should have a utilization rate of 80%. When they started this in March of last year, it was at 73%. Why the government has to guarantee a utilization rate, I don't know, but let's play this game. It's at 81.3%, above the 80% today. It's been above 80% since September. So we should, declare victory and end these tariffs as quickly as possible. The exclusion process is a joke, and I'm going to let my colleagues talk about the details. There's nobody who keeps a pulse on the numbers than Mr. Dankler here, who has a chart that he'll talk about that's unbelievable. But my folks have tried the steel exclusion process. It didn't work very well back in the 2001. It doesn't work right now, so that's not a solution. And I just want to also tell you that we have a tough job, those of us on the pro-trade side, because the other side has a very easy slogan, import steel, American jobs. The steel industry will say, well, we're losing our shirts. We have to explain about how how imports and trade benefit America. And Scott Lincicome from the Cato Foundation he put it on a T-shirt about why our side has such a difficult time. This is our argument. Tariffs not only impose immense economic costs, but also fail to achieve their primary policy aims and foster political dysfunction along the way. I mean, we have a tougher argument.
And shirt made in Mexico?
Yeah, exactly. Okay. By the way, it's available on Amazon, and all funds go to an educational foundation that helps teach economics. So, I like to use that because we do have the tougher argument, and I think one positive benefit, and look, I have Republicans and Democrats, but I think if we can see a silver lining in this, it really has redefined the debate on trade in this country, because I think particularly Democrats have gotten away with criticizing trade, but not really having to stand up for it. And now we're going to see the consequences of it. So we're in a battle. My job is to keep the focus on the 232 steel tariffs, because we could just see last week with the 5% tariffs on Mexico, it's easy to lose focus. June 1st, Saturday, was only the 1 year anniversary of full implementation of the 232 tariffs. As you may recall, they were first implemented on March 23rd, but the president exempted Mexico and Canada and the EU and a few other countries while negotiations happened. And those negotiations failed, except for Australia, I guess, and he fully implemented them. So, I'm happy to answer your questions, but my guys are hurting out there, and you're not seeing it in the job number, but they're getting very worried.
We'll get to that in a second. Back in December, I met with the New Zealand foreign trade minister and the prime minister. They were here in Washington, and this was they were trying to get the exclusion. And they looked at me and goes, what did we ever do to the United States? Mm-hmm. We're New Zealand, we're a little tiny country. Why us? Well, we thought we were, comrade in arms. We've been with you all the time. We went up there and argued, nope, no exceptions. So it was really unusual. So your comments are well taken. By the way, before I forget, is there anybody here from the White House? I mean, you don't have to raise your hand to identify. It's not that far. It's just a couple blocks away if you want to try, but we know you're out there. So I just want to point that out. We're aware of that. Yeah, that was, it's interesting. So speaking about, we had in the last one we were talking, we got into the subject, and Catherine's looking at me, autos and auto parts. Well, let's just go to the industry. So our next panelist, Catherine Boland. Catherine is the Vice President of Legislative Affairs for the Motor and Equipment Manufacturers Association, MEMA, where she manages the association's efforts to advocate for public policy initiatives on behalf of suppliers. MEMA represents motor vehicle suppliers who provide over 871,000 direct jobs, the largest manufacturing sector in the United States. Catherine?
Okay. Thanks, John. So like John said, I'm with the Supplier Association. We have 871,000 direct jobs, 1,000 members, roughly. We're in all 50 states, so we are significantly larger than the auto manufacturers. We also have aftermarket manufacturers as well as heavy-duty manufacturers. If I go out and talk to my members, and I've spent a lot of time talking about trade with them over the last 2 years, and I will preface this, I'm not a trade lobbyist, never wanted to be a trade lobbyist. I'd rather be talking about vehicle technology, but this is where we are, this is what I've been talking about the last couple of years. But if I go and talk to my members and ask them, have you been hit by tariffs on steel and aluminum? Good chunk will raise their hands. Have you been hit by tariffs from China? good chunk will raise their hands, talk about the 232 investigation on autos and auto parts. Pretty much that covers everyone. Mexico throws in a whole new wrinkle. These tariffs are something that are hitting communities across the nation. It's not just in Michigan, Indiana, and Ohio. It's not just in the Southeast. It really is in all 50 states, most congressional districts too, to tell you the truth. And this is hurting. It's not just my large guys who are paying this. Paul and I have some overlap in membership. I have fastener members. I have metal stamping and metal forming members. 2/3 of our members are small companies. We are a global industry, but these are we have everything from large Fortune 50 companies all the way down to a small mom and pop with about 50 employees in Michigan or in Indiana or in Oklahoma, where I'm from, or what have you. This is not just a challenge faced by Michigan, faced by where you think of these. Whatever state you're from, if you're from the US, I would consider you an auto state just given the supplier presence. What's happening in the supply chain, particularly on the OE side, is we're already paying tariffs on steel and aluminum, we're paying tariffs on China, and these tariffs are challenging to pass on to customers. And by customers, I mean either a higher up the supply chain supplier or an auto manufacturer. If you're not able to pass those costs on to your customers, you're either swallowing them or trying to negotiate better deals. You cannot, particularly in steel and aluminum, you can't just go out and find a new supplier of your raw materials. You have to get those raw materials validated. You have to get your parts validated. So it's not just as simple as coming to the US and finding a steel producer. It takes months, if not years, to get that validation. So my companies are paying tariffs, and they've been paying tariffs for a year or more, depending on where they're from, or they're dealing with quotas. I know we haven't talked about the quotas very much, but the quotas that are in place under 232 on steel and aluminum are hard quotas, meaning once you meet that quota of what's coming in from whatever country, and if you're an auto supplier and you have one validated supplier of that material, when that hard quota is met, you can't bring that material in for that quarter. That material has to go back to where it came from or get destroyed. I've had one member company who came to me last year when the quotas were put in place on Brazil on steel and said, he's like, what are we gonna do? He's like, if we can't get this steel, we will have to close a facility. This isn't a facility you wanna close. You close down, like Paul said, we lose our employees. You can't get those employees back. So that company has made other arrangements. They've been able to address it, but they're limping along and they're really looking for ways to get around what's happening, and they are working to find other steel producers. That's just one sample. I have other companies who've come to me as a tier 1 and have told me that they have tier 2s or tier 3s or lower supply chain, small businesses who are at risk of going out of business. So they're doing everything they can to keep that supplier open, because this is not, as Haley mentioned earlier, this is a very much a just-in-time industry. It is a lean industry. If your supplier goes out of business, you can't fulfill your orders for your customer for the next week. You either have to find a new one or you're going to have problems. So what I have member companies who've done, my large tier 1s, they have either floated payroll for some of their smaller tier 2s. That's last resort, but just to ensure that those tier 2s don't go out of business. I also have member companies who have reported to us that they are paying higher unit prices than they had originally contractually agreed to, just to keep those suppliers in business, because they rely on them just to meet their own customers' needs, whether their customers are higher up in the supply chain or whether they're automakers. This is not unique to these 1 or 2 companies. This is across the board. I've been with MEMA about 14 years now. We have not seen the economic uncertainty from our member companies since the economic crisis of 2008 and 2009. My members are reporting that they are very concerned about the direction their businesses are going. They're very concerned about the economics that their companies are facing. And that's about what's in place already. We talked a bit about, the first panel talked a bit about the Auto 232 investigation that has been postponed for 6 months. I will start this segment by saying The auto industry and auto suppliers are not a national security threat. We find it preposterous that the Department of Commerce found that. We find it preposterous that the president has agreed with that statement in his proclamation. We've maintained since the beginning of this that this is an unfounded misuse of the statute, and the president shouldn't be undergoing this. If you look around, there is no such thing as a US manufactured car, whether it's a Ford or whether it's a Toyota or anything in between. It's going to have imported parts in it. And it's, I mean, we have a lot of global automakers who are in this country who have brought their global suppliers to this country, whether they're Japanese, whether they're German. These are all my member companies. They're not employing foreigners at these facilities. They're employing South Carolinians, they're employing Indianans, they're employing Michiganders. Hoosiers, sorry. We've had this conversation before, and I will continue to call them Indianans, but they're employing Hoosiers, they're employing Americans. This is not an industry that is a threat. Haley mentioned the R&D spend, $19 billion a year. It is a significant spend. The global companies, whether it's a global automaker or whether it's a global supplier, they compete internally with their foreign counterparts, whether it's German supplier who has a North American presence, a European presence, and an Asian presence. They compete within that company on where they're going to be doing the R&D. With this much uncertainty, with the uncertainty that tariffs are bringing, that R&D is not coming here. And once that R&D is put in place somewhere else, it's not coming back here, because these are such significant investments that we're going to lose it and we'll never get it back. I have member companies who've gone to, well, and it was mentioned from the Wall Street Journal article, I have member companies who've gone to Mexico from China, and now they're facing Mexico. I will say with Thursday's announcement, we sent out a blast message to our members. I have been fielding dozens of emails, and we've had hundreds of our members on the phone both today and Friday. This Mexican tariff threat is a very real concern, and it could have devastating consequences with my members. Those parts go back and forth multiple times, many times, most times probably, by that same company, whether it's an American-owned company or a European-owned company. They're not really Mexican-owned companies. They're companies who have gone to Mexico, whether it's for labor rates or something else. There are parts that have not been made in the US for over 30 years. I'll use a wire harness as an example. It's basically the nerve system of your car. There's, depending on how many doors you have and how many electric things you have in your car, you could have 6 or more of them in your car. Those haven't been made in the US since the 70s or 80s. It's because this is a very labor-intensive job. They're put together by hand. The wires, the IP, the connectors, much of that is made here, exported to Mexico, exported elsewhere, low-cost labor countries where it can be put together and then comes back into the US or wherever it's going to be assembled. That's not something that's coming back, and it's not because of trade policy. It's because we have a skilled labor shortage at this time that we wouldn't find enough workers who would be willing to A, do the jobs, B, that we can pay them enough to put them together, and that it would make it a cost-effective option for a supplier or for an automaker to use in vehicles. The price would jump dramatically. What we'd rather do is keep those high-tech technologies, the automated vehicle technology, the fuel efficiency technology, things like that here, and let the lower cost, lower technology, lower IP type work go elsewhere, whether it's Mexico or Canada. But these tariffs are not going to bring these jobs back. It's just going to make the price that we have to pay and that will ultimately get passed on to consumers where possible get paid. That's kind of some of the high points of what we've been facing, and I look forward to any questions.
Thank you, Christine. I want to make a comment that you also brought up, Paul. I've been doing this for a long time, and I would say since it used to be going back in the 80s and 90s. Yeah, I'm dating myself. 80s and 90s and early aughts. I mean, trade was just like only us trade wonks that people were dealing with all the time were really interested in it, and nobody else knew about it. Since President Trump has been elected, trade has elevated to the top. For those of us who love trade, I'm so grateful, contrary to all the problems, but it is at the highlight of everything. So it's amazing. But like you said, look what we're dealing with and look what we have to. And can you get the average person out there to clearly understand this is going to affect them? May not affect them today, but it will. I mean, those who like their guacamole, if they keep going, they hit the 25% by October on those avocados. There's only so much you can get out of California. I hate that thought, but anyway. Our next panelist is Christine McDaniel. Christine is a senior research fellow at the Mercatus Center at George Mason University. Her research focuses on international trade, globalization, and intellectual property rights. Christine has held several positions in the U.S. government, including Deputy Assistant Secretary at the Treasury Department and Senior Trade Economist in the White House Council of Economic Advisors, and has worked in the economic offices of the U.S. Department of Commerce, U.S. Trade Representative, and U.S. International Trade Commission. So kind of an inside view, Christine, so it's yours.
Well, thank you. Thank you. And thank you so much for coming out, and thanks for GW and WIT for holding this. I also teach applied econometrics at GW, so I don't know if any of my students are here, but if you, hi. And so anyway, I've really come to appreciate the GW campus in recent times. So much of what you guys have said, economists have been saying for a long time, and it's kind of nice that you guys are finally saying we have an opportunity to say this out loud. But the downstream effects of trade protection, trade remedy regulations have always been there, and for better or worse, this administration's actions have really given us all an opportunity to really focus on those downstream costs and downstream effects. And like Paul was saying, from the Bush steel tariffs, looking back, we really years after those came off, we were able to see the sort of ex post analysis and see the effects of the unemployment of jobs in steel consuming sectors versus that in the steel industry. And like Paul said, more jobs were lost in steel consuming sectors than existed in the steel industry ever, even initially. And most of those jobs did not come back. And so when the tariff exclusion request process started under 232, we started to think, we started to get questions from different people, around town, Hill staffers. What do you guys know about this? What are the downstream effects? And at first I thought, well, we're going to have to wait a while. But then we thought, well, wait a minute. We have the tariff exclusion requests are being filed online. And so Danielle Parks, who's here, my brilliant research assistant, who sadly I will lose to grad school in the fall. So this gave us a chance to, basically, we scraped the tariff exclusion request database on regulations.gov. And it was a chance to see downstream effects in real time. And the last time we updated this was mid-March. We're in the process of updating it again. And we keep all this data publicly available on quantgov.org. And you can see it by state level, by congressional district level. All the flat files are there. And you can see this, in real time intel on the downstream effects. And so we see it in the data, and then of course we have the real life stories in front of us as well. And so what we're, and the more you look at this data, the more questions arise. And you'll recall that Secretary Ross initially expected that they would get about 4,500 tariff exclusion requests for steel. Well, fast forward to today, and they've received over 50,000 tariff exclusion requests. Then there's also an objection process. So in other words, they grossly underestimated the downstream effects. Then, and then we looked at other, there's many ways you can cut this data. We also looked at objections. And the objections are really interesting because it turns out that, only a handful of steel companies are filing the vast majority of objections. And these objections are really important because once you file a tariff exclusion request, if you get if there's a steel company out there that objects to your request, it basically kills your chances of getting approved. Of all the approvals, less than 1% of the steel approvals have had an objection. So getting an objection to your request basically kills it. And for aluminum, it's less than 5% as well. So it's, these objections matter. Then we looked at, okay, who's filing these objections and what can we learn about that? And then we saw that if you aggregate the data in terms of the steel companies filing the objections, in terms of the quantity of steel they're objecting to, the steel companies are objecting to more steel than they could ever make anyway. And so, you know, that raised more concerns, because if just one objection can kill a request, then shouldn't we be taking each objection seriously and maybe looking at it in context? And there's no indication to us that that's happening. So there are a number of stories you can tell with this data, and we hope that you go to quantgov.org and more researchers will use this data. As I said, we're updating it again, so pretty soon we'll have another piece out. More great news. As of May 30th, I think, 30 or 1st, it will be out in terms of when the data will be, probably will be out in June, but it will be up to the end of May. I guess one thing to keep in mind is, down the road, I want us to, really use this moment to really understand the downstream effects, because this goes way beyond Section 232. You look at anti-dumping countervailing duty law, our statutes, and by statute, the International Trade Commission, which is the agency that makes a determination on those, they are not allowed to take into effect downstream effects when they are looking at whether to go affirmative or not on anti-dumping duties or countervailing duties. They can only look at the, a handful of factors, but downstream effects is not one of them. And so, we are not, at Mercatus, we are not going to stop after the 232 tariffs go away. We are going to keep on the path of highlighting the effects of trade remedy regulations, and keep highlighting the importance of changing these statutes to force government agencies and the executive branch to take into account downstream effects of trade remedy regulations. Thank you.
Thank you. A comment on the Commerce Department. I work really because of my position in the district export councils, and as I said, haven't been appointed by the secretary, but I work closely with senior officials at Commerce, and I'm a little upset with them right now, because one of the things I work is on trade promotion, and especially on exports. It's always about trying to increase our exports. And what's happened because of all this is that the Commerce Department had authorized funding, and what they've done, that money was to go over to trade promotion, and they took the money and they're using it in trade enforcement. So you have commercial service officers, both in the domestic offices, there's a shortage of those officers who are working on exports and actually promoting exports and assisting small companies, even large companies, on export promotion and providing their services overseas, working through our commercial service office over there. There's a shortage because the people are there, but they've been moved over to enforcement, all because of this.
Yeah, well, but in fairness, that was a long time coming. I think this shift to enforcement has been a long time coming, and so it's not like President Trump realized that there was a lot of anxiety over import competition. I think he just really gaslit it and really took it further than anyone thought. But that's right. Enforcement efforts have increased and taken resources away from other functions.
Yeah, and there's just funding, the stuff that we're looking at, and the positions that are short overseas. So, and it's again, we're trying to promote U.S. goods and services around the world, and it's nice to be helpful for me. I travel a lot, but a lot of the countries I go into, and the amount of Chinese companies that are there, doing business and what they're doing is absolutely astounding. So but we're not talking about exports right now. We're talking about the other thing, but it is a consequence. The next person I want to introduce is Mike Dangler. Mike is the Chief of Staff to Representative Jackie Lorsky of Indiana, the 2nd District, who sits on the Ways and Means Committee in the U.S. House of Representatives. Mike, she's a Republican, and she's a free trader, and what happened to the Republican free traders? That's my question. What the hell happened? We were talking about this before this started, and it used to be the Republicans were all about free trade, and all of a sudden, as somebody said, we said in the earlier panel, everybody's afraid to say anything against us now, and have gone completely silent. I don't understand this, so maybe you can help explain it.
Yeah, I think everybody's just on their heels trying to, like Thursday, everybody's just trying to digest and understand and figure out how to react, because a week later, something else might come along. And yeah, my boss represents a district in northern Indiana, and it's a district, we're talking about the unintended consequences here, and it's a district of kind of unintended consequences and collateral damage. Obviously, Indiana, big ag state, you got a lot of soybean and corn farmers, dairy farmers. But not just that, her district is actually one of the biggest manufacturing districts in the country. It's home to Elkhart, Indiana, which if it doesn't mean anything to you, that's okay, but if you own an RV, it probably came from Elkhart. They do about 80% of the RVs you see on the road, which still astounds me. When you drive down to Florida or something and you see a big lot of RVs, those probably all came from Indiana, and somebody had to drive those down. Also do a fair market share of pontoon boats, a lot of trailers, like cargo trailers, horse trailers, things like that. And a lot of auto suppliers. We're kind of midway between a lot of the Japanese investment that's in Indiana and the automakers in Detroit. And so especially the manufacturing side of things, they use a lot of steel and a lot of aluminum. We also do Humvees. So it's just a massive amount. And so right when the tariffs were announced, when the investigations were announced, we heard from folks saying, hey, our prices are going up. And so my boss is a new member of the Ways and Means Committee, was still trying to figure out what she wanted to kind of dig into. You always have to kind of be mindful of other people's turf and what your district's doing and everything. And so we kind of kept an eye on that because it was in the investigation stage. And so there wasn't a whole lot to do yet. And then the tariffs were announced, and here we are over a year later. And so we've been doing everything we can to fight back against some of that collateral damage. We have, but I think her district makeup gives us a little more leeway than a lot of other districts. So, and you just think about the fact that on either side of our district, the 1st district to our west has Gary, Indiana. So huge steel, steel workers and steel companies and everything there. The district to our east, Indiana's 3rd district, has Fort Wayne, which is the headquarters of Steel Dynamics. If either of those were in our district, it's a different story. We wouldn't have the leeway from our constituents to get involved, but with what we have in our district, that allowed us to get involved and be a little more vocal than others might have been able to, because our constituents weren't, we still had constituents, reaching out mad at us, but we got a little more leeway there. So, been very aggressive. We honed in first on the steel and aluminum exclusion process, and I'll get to that in a second. But we fought for changes to that, just trying to minimize the collateral damage, I think, because we realized, especially early on, saying don't do tariffs wasn't a winning argument. You can stand in front of a runaway train, you're going to get run over, and the train's going to keep going. It's not going to know any different. So, and so, when the auto tariffs came along, we were able to do a letter on that and marshaling all of the associations together, I think for the first time. And I never fully appreciated how many different auto associations there were between the OEMs. There's a couple there. I think there's only one Partsman.
2.
Oh, okay, 2. Oh yeah, aftermarket. And then a couple of dealer associations and everything else, and RVs, because RVs would be an unintended consequence of auto parts, because the tariff code doesn't distinguish a part that goes into a car versus an RV. So once again, a big stake in our district for that as well. And we just did another letter on autos this year as well, renewing our concerns. But the first letter got 149 signatures. This one got 159 this year. Last year, we also, not 232 related, but again, fighting back against the collateral damage, asked for a list 3 exclusion process for the Section 301 tariffs on China. That one got 169 members. So we've been trying to kind of, I think a lot of members have a hard time. They say, okay, yes, we're free trade, but we have problems with our district trying to figure out how to push back and what's the best way. And so we're trying to provide that platform to people and to kind of say, hey, you can jump in, the water's fine, here's a way to do it. You're not going to end up in the president's Twitter feed, and this is the way to serve your constituents, voice concerns, but also not get crosswise with the president. So, but the thing we've definitely honed in on is the exclusion process. Early on, it was very clear that it was very broken. We heard from companies in our district, and so we kind of got a little interested in it. And I started an Excel spreadsheet, just kind of tracking things, exclusion requests, objections, things like that. The steel exclusion or Excel spreadsheet now has over 137,000 entries, and the aluminum is over almost 18,000, and that doesn't include all the data sets and everything. So literally on my steel Excel spreadsheet, when I hit save, I have to just kind of walk away from my computer for a couple minutes, or else I'll lose everything, because it just takes that long to save and calculate all the formulas and everything. So, but I called around because I thought, okay, if this is the process is broken, things may be happening that we're not aware of that are happening to other companies. And so I kind of early on just kind of cold emailed all the companies that were going through the process and got a huge feedback from people, and kind of also realized that across the country, we're serving our constituents obviously with the companies that are there, but a lot of these companies were selling into Elkhart, into Warsaw, into some of these other great Hoosier companies that are, because they have a nationwide and global supply chain. So we've been kind of doing this constituent service and just keeping tabs on everything, and just looking for all these intricacies and problems and everything. And so, with the exclusions, obviously there's a GAO report we're watching, and we've been working with Haley and Senator Toomey's office on that, and hoping that can help shed some light on things and just get some more eyes on this, because I think right now, we had a hearing in the Ways and Means Committee on the exclusion process in July of last year, but we haven't had anything since. And obviously, since the House flipped, we're no longer in control. We don't call the shots on what the Ways and Means Committee holds a hearing on. So, we'd love to see another one, but it's not our call. But as we're continuing to dig into the exclusion process, and as they're starting to release decisions that went through the rebuttal and surrebuttal process, which was not a feature early on, there was no rebuttal and surrebuttal process. So it was your word against the steel manufacturers that objected to you. And as my boss said, it's a very, very expensive he said, she said. But so thankfully they got that, but now we're seeing the fruits of that and crunching the numbers. And, as Christine pointed out, we're seeing, objectors biting off more than they can chew, and now they're getting approved. And so one of the more extreme cases that I've seen was a company requested 9,000 metric tons of steel. The company objected all of it. They, in their objection form, said they can make 3,000 metric tons in their whole plant. Didn't list their capacity utilization, so probably even less than that. All of it got approved, or all of it got denied, I should say, which means that company now has 9,000 metric tons of, I guess, an order, but they can't produce it. So it's things like that where we're kind of saying, well, what are you looking at? And so we've sent some very detailed letters with examples like that, basically calling Commerce to the mat and saying, all right, explain this. We haven't gotten any answers because I don't think they want to answer those questions. and I could talk for another hour about all the other things that are wrong, because I look at this every other day, because if I don't, then I'm going to get really behind on the spreadsheets. But we're keeping an eye on it because we have to, and because if Commerce doesn't think anybody's watching, then it could get even more egregious, but I think it's pretty egregious right now. So one thing I do think that will help, that I do give Commerce credit for, is that they're trying to create a new portal. And I think that will help with some of the clerical issues that are out there. Obviously that doesn't speak anything to the ultimate decisions that are made. But I think they have put some work into the portal, been fairly deliberate with that. It just hasn't launched yet. And when it does launch, it doesn't sound like it's gonna, we'll still be dealing with regulations.gov, which is what it is. So I've discovered the quirks of that website. So, but I'm happy to answer questions about that. I do kind of email around statistics on the tariffs, or on the exclusions. So I have some of those, a little cheat sheet in case people have questions. But happy to take questions.
Thank you, Mike. A comment that Alan made earlier on the previous panel about that the president has just unfettered access to do whatever he wants under 232. My concern is what's next and who's next. And I think our trading partners around the world are thinking the same thing. And that's not who America is. That's not who we are. Everybody looked up to us. And I know all my travels that I've gone through, and people look to, they want to deal with the United States. They don't want to deal with anybody else. They want to hear. But now they're starting to backtrack and go, what are we getting ourselves into? Is this going to come back to haunt us? So it's a lot of concern. So this is not this is what the idea to get behind is, but this is what's happened. So right now I'm going to open it up to questions to the panel. If anybody has any questions that would like to address the panel on that, so any of these issues, please come on up to the mic.
Hi, my name is Yasko. I work for Sumitomo Corporation of Americas. I have been tracking the exclusion process and realized that, well, thanks to Mike's hard work, there have been changes. But I realized that there is no way for companies to prove that objections are, in fact, false. It's very difficult. But with your experiences in, facilitating the changes in rules and the processes in commerce, what can be done to basically allow companies to address the objections, the reality or the truthfulness of the objections? Because sometimes tariffs are blowing multiple year of profits of certain companies, and it really affects it could be fatal to certain companies. Thank you.
Yeah. So, that's something that we're trying to dig into now. Obviously, we've been waiting to see the results of the rebuttal and surrebuttal process. We've had questions about the objections, their accuracy, their truthfulness, and sometimes some of these decisions have taken over 400 days, and so the fact patterns just could be completely different. And so we're kind of entering this new phase where we're trying to figure out, the standard that Commerce has used is that it has to be produced in 6 weeks. And so, we kind of don't know what Commerce is using. I mean, we've pointed out that some of these say well beyond the standard, and so, we just don't know right now because we haven't had enough kind of cases come forward yet as to, if they say, or is it 8 weeks? I can't remember off the top of my head, but okay, it's been 8 weeks or 6 weeks, and we haven't gotten our order. What now? And we don't know. We've asked Commerce, but they won't say. right now what they've kind of said is that you just have to file all over again, which doesn't make sense because it's not your fault that they didn't deliver on time in the quantity and quality specified that they said they could make it. So I think that's going to be a bigger fight coming up. Like I said, there just haven't been enough, there hasn't been enough time elapsed and enough cases kind of that have hit that point yet, which is unfortunate, but we kind of have to get to that.
We're trying to make the exclusion process, we're advocating that it run as smoothly as possible. As I said, we don't think it's an answer to the problem, that we need to get rid of these tariffs. But there are so many stories out there. I have a member who, their purchaser sits at home and just presses refresh on the site, because what the steel industry does is they wait till the last possible moment to file their objection. And then if you miss it, then you can't file your SEER rebuttal. And as Mike has the numbers, that if the steel company objects to your exclusion, you're not going to get it. I mean, there are very few cases where you're going to overcome that objection. So you know, I have a company that, I mean, they've filed a lot of exclusion requests, and they were only successful on 3%. So they went to every domestic supplier. They were getting their steel from Canada. This was before they were lifted, and they documented the responses they got from the U.S. companies who had objected. We can't even quote. They said, we can't quote your price for 6 months. We're not interested, or you know, here's the price that they could never afford. So, you know, it's a big problem.
And they still didn't get it?
And they still didn't get it. So we're going to continue to advocate, and thanks to Mike and his allies on the Hill, trying to improve that process and keep their feet to the fire. But it's not. And by the way, the exclusion, if you get one, is only good for a year. And we're about to have all these that were approved at the beginning of this process expire, so they have to go through the whole process again.
Yeah, and I would just add, you know, what is the point of having a tariff exclusion request if just one objection from a company that may or may not be able to make it can derail the whole thing? I was just thinking when you were saying that, like, how about, you know, when we're talking about ideas to improve this system, how about Commerce? Do you think it would help if Commerce required the steel companies that objected to document their annual production over the last 3 years, and to prove that they could still make, like if they make this, if it wouldn't exceed 100% of their average annual capacity over the last 3 years? You know, I mean, in a way, that's really the only way to fix this objection problem, right? You've got to put the burden back on the steel objectors, or aluminum objectors, but it's mostly steel. And the real question is Commerce really prepared to do that?
Right, we're giving a veto power to a company to say, my competitor.
It's in their incentive.
Should my competitor be able to supply this customer steel? So of course they're going to object.
I have a member company who's had a pending request since early in the process last year. They had objections filed by a domestic steel company that they had tried to work with in the past. The company was never able to meet their specs or get their product validated, so it wouldn't meet the vehicle manufacturer's needs. Basically, it would be an unsafe product on the road, and no one wants that. But the steel manufacturer filed an objection. Obviously, when the rebuttal and rebuttal process came out, they filed a rebuttal, but that exclusion request is still sitting out there and has not been approved or denied yet. And the steel company that objected has not been able to demonstrate that they can make this particular kind of steel, meeting those specs.
My question is for Mike Dankler. You were talking about how your boss has been very successful in getting a lot of bipartisan signatures on letters on various tariff-related issues, and that y'all encourage them and say this is a safe way of representing your constituents without getting crosswise with the president and without ending up in his Twitter feed. So I wanted to ask you about the Mexican tariffs that might be coming, that IEEPA, there's a disapproval process in it. So what is your handicap for whether there would be enough Republicans to say, no, we don't want up to 25% tariffs on all Mexican imports?
Honestly, I've kind of given up prognosticating on those types of things. It is way too tough to know. You know, I know that there's a Mexican delegation coming in. we're watching that really closely, and really hope. I mean, I think that's at the end of the day going to be the biggest shot to at least postpone them, if not lift them, hopefully. But you know, it seems like what they like to do is postpone things and keep the sword over your head. So, but so that's, you know, who knows what the resolution would be, what the count would be.
There's few profiles and courage in this town. Hats off to Mike's boss and to Senator Toomey for being a couple of the folks on the Republican side who have really spoken up on behalf of steel-consuming industries. So.
Can I just say a word about the exclusion process? The reason the exclusion process is necessary is because there's no correlation between the asserted reason for the tariffs and the actual reality of what our needs are in terms of foreign suppliers and domestic users. And if it had been a normal administrative proceeding, those two would have had to fit together in some rational way. But because the president can do anything he wants in any way he wants, there's no connection between them, and that's why you had to have an exclusion process. The exclusion process, even if it worked perfectly, which obviously it's not doing, would not save the statute from its unconstitutionality in any event. And the last thing I'd say is I hope that if cert is granted, I can call on some of you to get your members together to file some amicus briefs to tell these stories to the court so they understand exactly what's happened and show how bad the exclusionary process is and how badly it's affecting people it's supposed to benefit. Thank you very much.
Does any of the panelists have a question for another panelist? Hey, it works that way, you know. Okay.
I don't, but I mean, one thing to just add on to that, and I guess that I was going to say before, is that, you know, for a lot of the folks that I've talked to through the exclusion process, you know, they feel, especially early on, they felt really defeated. You know, one guy said, I'm just a small guy. What am I supposed to do against U.S. Steel? Like, I'm a nobody. He literally said those words. And so it's, you know, I think that's who, you know, Paul and I are kind of fighting for is the people that, you know, don't, and trying to get information out to them and help them understand what's going on and how this will impact their companies, and because they're ultimately kind of suffering in silence because if they close up shop or something, maybe the local paper will cover it, but the Wall Street Journal won't, and none of that's going to break through to people until probably it's too late. And so that's, you know,
it's 25 jobs there, 50 jobs
there.
Yeah,
it all adds up, but it's a lot of drops in a bucket, and it takes a long time for that bucket to fully fill up. So.
And then once it's filled up, it tips over and it's too late.
Right, and we're the steel industry's customers. My guys are the domestic steel industry's customer. The domestic steel industry does not export. Maybe a little they do to Canada, but they're not, that's why they can take these positions, because they don't participate in international commerce like my guys do. When we don't do well, it's only a matter of time before they don't do well. Right. So they're shooting themselves in the foot. We saw this in the 201s. So I don't have to tell the economists on our panel. It's going to hit. It's a losing proposition for them, and we've never learned our lesson, it seems. So.
Any more questions? No, I think we'll let everybody go early. I want to thank the panel for being here today and handling this difficult. We're just at the tip of the iceberg right now, and it scares me to think about what's coming next. And again, we get back to with the automobiles and the parts, and come to October, if the courts don't rule and don't stop it, and they impose this, I can only imagine what's going to happen from the other side. And what you said earlier, and which was brought up in the earlier panel about there's nobody. You can't find anybody out there that there's not a problem. Don't do this. And particularly the automobile industry. Right. You know, the guys in Detroit are saying, you do this, what's going to happen to us in these other countries? It's going to kill us. And in contrary to, in a reading, as you all know, that, and going back on the thing with Mexico, that three. Trade Rep Lighthouser and Secretary Mnuchin and even Jared Kushner begged the president, don't do this. Don't do this. And that's three senior people on trade, but there's somebody whispering in his ear, got an idea who it is, to go to do this. And I'm afraid that what's going to happen if they don't stop this doing. And I think that working on previous trade issues that we've had and going up on the Hill, I've had a number of members of Congress always tell us to go out to our members and can you write something to the local newspapers, the local television, so people locally can see it? They don't want to see what's coming out of Washington. I know that Barbara's Comstock, when she was in the House, I met with her, and we were talking about reauthorization for Exim Bank a couple of years ago. And she told me, she said, John, could you please don't do an article in the Washington Post or the Washington Times. Come to Leesburg and do an article there so people can see it, the local, how it's going to affect it here. Because she was telling me she was getting objections to the reauthorization of Exim Bank at 10-1. And I said, I could walk down, you've all been to Leesburg, I could walk downtown, middle of Leesburg, and ask 100 people, tell me what about Exim Bank? And they would, I bet I could only find one person that could tell me about it, yet it's running 10-1. And this is what you're up against. And you have to get out to the local areas, into the districts, into the members, into the regional and their district office and talk to them. They need to hear this information to convey it back, to be armed, to come back to Washington. This is what's happening in my company, these local companies. I got proof. This is what's going on. Exactly. So with that, we'll let everybody out of here early. Thank you very much for coming, and thank you, Anna, for having us. Thank you.